All right, good morning. We're going to get going here in just a few minutes. As usual, we have, there's always a few stragglers or IT issues that come up. And so we have a few videos that we'd like to share with you while we're just waiting for the last of our folks to join us.
Okini sukuaks, it's a getsa suksamatsa nohpua. Anoxus, ni stu anakoki naktuk, ni dump tu am skapi pikani, itunyo pi omach spotsi. Hello, my relatives. It is nice to see you today. My name is Little Pine, and I am an enrolled member in the Blackfeet Nation in Browning, Montana. And I am proud to be a Blackfeet.
Kisukyuke, Unini Kinna Hamu, Who's House Kanik Witskanuk, Unini Kasanka Smucknik. Hello, my name is Miley Kai. My Indian name is Holy Shirt. I'm a member of the Kootenai tribe. I live in Elmo, Montana, and I'm proud to be Kootenai.
Shoda, Balasha Riley Singeruk, Biluga Walasha, Pacha Halin Chilabug, Bilukasaka, Kadish, Bilishisana, Chilabum, Pacha Halin and Gekal, Goiwi Lashilik, Biu with a suck, Bibil Gosh Bagarik, Be up Salokuk, Ashpachik Chekugawuk, Be up Salokuk Palasai Chick. Hello, my name is Riley Singer. My crow name is Pacha Halin Chilaba, meaning bull in the clouds. My grandfather, Victor Singer, went on a vision quest and had a vision. He looked up in the sky and he saw a bull in the clouds, and that's where my name comes from. I am a member of the Greasy Mouth clan and a child of the Whistling Water clan. I come from Lodgegrass, Montana. I am Crow, and I am very proud to be a Psaluga.
Nihana Nisa Wosig, Nia Haban, Nana Ani, Nisan Hattus gets no one, Ni Dan Be Dan, Watanahan Ani Watanahanin, Nanisu Hatsnats, Nisi Idan Natsata Naniswag. Hello, my name is Ghost Calf. It's good to see you here. I'm from Fort Belknap. I'm White Clay. I'm 12 years old. My teachers are Cree Woman and Two Capture. I'm proud to be White Clay.
All right. Well, welcome back. I appreciate you coming, turning in for day 2 and taking time to be here today. So I guess from yesterday, I'm just wondering if there's anything that anyone thought about overnight that they just think is so important they should share it with us first thing this morning. Well, if you think about something throughout the day, there will be other opportunity as we get later in the morning to jump in and share thoughts on things. So we are going to move along this morning. We are very happy to have Chief Judge Stacy Forstar here this morning. And Judge Forstar is going to give us all an update on the Hayland versus Brackeen case. And so Judge Forstar, I guess I'll turn it over to you this morning. If you're
Justice Gustafson, I just sent you a message. She is almost done with a quick hearing, and she said she'll be about 5 more minutes.
Okay, so
She wasn't supposed to get started till 8:45.
Oh, well, but I wanted to leave time for our team breakouts more later today. So I didn't want to get too involved with talking about other issues. I guess Brooke and Heather, do you want to kind of finish up where you were yesterday before Judge Forstar gets here?
Sure. Hang on one second. We just had a few more slides on the active efforts, and so that might be just perfect timing.
All right.
Okay. Okay, good morning, everybody. Welcome back. Thanks for coming back. We left off talking about active efforts, and hopefully you're not getting sick of us talking about compassion. But again, we were just so inspired by this article and the discussions we had in Arizona about incorporating compassion into our work. And it really kind of incorporates every aspect of the work we do. And one of the things that came out of the article was the mindset focusing on, if we tend to focus on the concrete services provided to a family. So for example, you need to go get your chemical dependency evaluation, go get your mental health evaluation. We need you to drug test, go to the parenting class, that sort of thing, and talking about compliance. And when we have that mindset on concrete services, it misses an important element, which is compassion. And I think we touched on yesterday, but that parents reiterated that what was more important to them was the focus on their needs, and that if the worker and all of the stakeholders, if they felt that we were willing to help them overcome those obstacles and treated them like individuals, that was much more impactful for them in their success. So this is just a chart that we put together. We actually came back last night and revised some of these based on some breakout sessions and what we heard from the tribal panel. And so we just kind of wanted to juxtapose the reasonable and active efforts. And so on the reasonable side, a couple of examples would be handing a parent a completed treatment plan. Obviously, that's not active or thorough, like we know the definition of active efforts needs to be. We also know from the Supreme Court that it needs to be more than passive. So that obviously would be in the reasonable chart. Handing parent a list of providers, and a list of housing. So for example, well, your treatment plan task is chemical dependency providers. Here's a list, go and complete this. Also would not be active or thorough or timely. So let's compare that then to what an active effort would look like. So for example, in the treatment plan realm, rather than handing a parent a completed treatment plan, we could start with a blank slate. We could meet with a parent to collaboratively determine what their needs are, right? Coming back to what I just talked about, incorporating compassion and asking them, what do you need? What do you need to heal your family? The research shows that from that article that if a patient has buy-in and feels like they're being heard, that there's more adherence to treatment. And so correlating that to the child welfare practice, that makes a lot of sense. An active effort also in the realm of treatment plan, collaborative planning, would be not just offering the traditional or Western services. So I think that would require some really, it seems redundant to say this, but active effort on the part of the social worker to really understand who the community partners are. And even in some of the traditional service providers, we know that some of them do offer a Native American component. So for example, when we were getting our family recovery court going, we met personally with the Rimrock Foundation folks and said, hey, this is the population that you're going to be serving as one of our 2 providers. And so we need to know, are you willing to incorporate some type of programming that is more, is a best fit for our participants. And so they do have the medicine wheel option. And then of course, we also have the Billings Urban Indian Health and Wellness Center. So that is certainly an active effort, is to not just assume that parents are traditional versus non-traditional, but really finding that best fit. Reviewing, so instead of handing a parent a list of chemical dependency providers, or housing options, so the probation list that comes out, where we know that certain landlords will rent to people who have convictions and Section 8. Instead, we're going to review that list with the parents and assist in the follow-up. So do you need me to print this application? Do you need, let's take this office time to fill out this application. Let's get some of your quote unquote homework done, right? Making a game plan to ensure that you're assessing those barriers and making sure that there's a plan to overcome them. Heather mentioned yesterday a story in that article about a mom not being able to get to the bus station, really digging in and making sure that the parents are going to be successful. So that really is going to require that frequently asking the family about the barriers and not just assuming that they're able to complete those without further discussion.
And I think a rule of thumb would be in an ICWA case, and then Justice Gustafson in the chat just typed that depending on the circumstances of a non-ICWA case as well, that you should, as a social worker, not hand parents a list that you don't intend to review with them. So if that rule of thumb, if you have a list, that you're going to review it.
Okay, so this is, we wanted to talk about incarcerated parents because unfortunately we know, especially like in Yellowstone County, since I believe 2017, the number of dependency cases really parallel the number of felony filings related to drug possession primarily. And so we have the incarcerated parents, and we have to find a way to collaborate with them as well and make sure that their voices are heard. And part of that collaboration is giving parents hope, and even those that are incarcerated. So a reasonable effort might be sending a letter updating the parent about what's going on, providing the treatment plan through the mail. An active effort would be visiting a parent at a detention center. I had a status hearing recently, and we asked the social workers to provide us with a court update before every hearing. And I just couldn't have been happier. The report said that since the last hearing, he had visited the father several times at the detention center, and I just about fell out of my chair. I just thought that was so wonderful. And of course, we are going to have parents who are in Department of Corrections facilities. In my experience, case managers are really accommodating for social workers to set up phone calls. So even if out of state or out of town, we need to be finding a way to speak one-on-one with parents. Really important, something Heather and I try to just educate social workers about and help them get relevant documents so we can understand the status of those ancillary criminal matters, because that absolutely is going to impact their success. And so that may be making sure that they know who their defense attorney is, that they're making appointments with their defense attorneys before hearings, making sure they know when their hearings are. One thing that we experience a lot is warrants, right? And so making sure that we are referring them to their criminal defense attorney so they can get warrants quashed. Understanding what does their release order look like? If they are already required to do the patch, can we make that consistent? Or if we want them to do UAs, can their criminal defense attorney amend so that we're not duplicating efforts? All of that becomes really important to the parent success and is going to require a lot more than just sending a letter. Importantly, giving that parent a voice is certainly going to be in the active efforts category. So even though they're incarcerated, they may be able to make certain decisions still about their child's life, whether that's providers, medical care, school decisions, etc.
Also, I just saw that Judge Four-Star came on, but I think we'll finish the active efforts portion before we move on. I also saw in the note that Val in Cascade County noted that a parent's attorney made an argument that somehow a CPS worker needs to Mirandize the parent before visiting with them while they're incarcerated. And I guess maybe that parent's attorney, careful what they wish for, because my advice would be that the CPS workers then always invite that defense counsel to come with them to the jail every time from here on out. Also, I disagree with that defense, but maybe that's a discussion that our defense affinity groups can have today. The other active and reasonable example that we wanted to provide was updating the tribe and tribal social worker. And yesterday, I believe that it was Crystal from CSKT who mentioned, for example, not hearing that kids on her caseload had moved. In Yellowstone County, and I apologize, I'm not certain if this is statewide, but in our orders to show cause, there is it is ordered that our social workers let all parties know if there's going to be a move. And then I think that the active effort here is, as soon as there is indication of a potential placement breakdown, I think that for an active effort, then the CPS worker can certainly notify the tribe and let people know. What we also mentioned was this inviting tribes to participate in staffings. And I think depending on your jurisdiction, for us, that is monthly staffings with the department and the tribe's ICWA agents. And then I think, for other jurisdictions, it might be inviting all tribes at some point to call in. I think that, there are different options for how you can engage tribes on teams, whether that's recovery court type team communications or just individually. And then also, if there is the availability for the tribe, if they have the available personnel to help with, if there are services that are available on reservations or that they know of in the community, that might be helpful. As a practice tip, we wanted to again remind everyone that those active efforts need to be part of the record, and that past active efforts are not sufficient to meet the burden of active efforts. There needs to be testimony that's being updated, whether that's in the social worker's affidavit or in court. And then I would really encourage Parents Council to be collaborative if there are some suggestions that they have about, whether it's a new barrier that they've learned of for their client, or if they potentially are able to share additional about efforts that might be helpful. For the judges, we wanted to remind you again that on the bench card, there are findings to be making, and even if the finding is unnecessary, these kinds of discussions on the record are so important of, are there additional efforts that could be made that might allow the child to return home? And then to the parent, what else do you need from the department? During the hearings in which the testimony is required, the finding is that the department has made remedial services and provided programs to prevent the breakup of the Indian family. And then the department has not used those active efforts to prevent breakup and to reunify.
So one of the takeaways from Vivek's article talks about that when we are demonstrating empathy and compassion, it doesn't require a total shift in our daily practice. There's a great discussion of what we as stakeholders can do that are just small changes, and it's not necessarily going to increase the time for that interaction and require a overhaul in our policies, for example. That might be just body language, right? Instead of having our arms crossed that we're open, it might be just a smile at a parent. So that facial expressiveness can send a lot of message, and adjusting our vocabulary to reduce stigma. This isn't something new. We hear this a lot for me at drug court conferences, but it's always a nice reminder for me, even as a county attorney, that I can be thinking about the language, the words I'm using, and how that's impacting the parents. So rather than calling them mother or father in a hearing, that I'm using their name, and of course their correct name. I certainly have been guilty of using the wrong name, which is always embarrassing. So taking the time to review that before court. And I think in doing that, we're recognizing that they're a unique individual, right? And not just another case, not just another mother or father. So the words help to reduce the stigma in these cases.
Okay, so that is the end of our active efforts portion. If I'm going to stop sharing the screen, and then if Judge Forstar, I believe, is next on our agenda.
Hi, good morning, everybody. Can you hear me okay?
Yes.
Yes, okay, all right. So good morning. The panel, this is my first time getting to come sit in and listen, but it looks like you have a large group of people and everybody's on Zoom, correct? There's nothing in person? Okay, perfect. All right, so I just wanted to give a little bit of update on the Brackeen situation, and I went to a judicial
Judge
conference.
Forster, I hate to interrupt you, but I think some of our people don't really know who you are and what you do.
Okay.
And so other than telling them you were going to be here and that you're with the Fort Peck, Assiniboine, and Sioux tribes, maybe giving them a little bit of background of what it is you do before you tell us about that. Thank you.
Okay, so I know time is short, so I'm gonna keep this short, but my name is Stacy Forstar. I'm the chief judge for the Fort Peck, Assiniboine, and Sioux tribes located in Northeast Montana. And I know a lot of people probably don't come to this area because it's very rural and we're basically in North Dakota and Canada. And we have a land base that's very large. So we are about 110 miles. It's like 2.2 million square acres. So about 110 miles long and 60 miles wide. So jurisdiction wise, the court covers general jurisdiction. We have about a little over 13,000 tribal members. About half of them live on a reservation, but Roosevelt County is the biggest county that encompasses, we do have 4 other counties, but Roosevelt County is the biggest county, and it's about little over 10,000 residents, and half of those are tribal, half are non-tribal. So we're really 50-50. Reservation is checkerboarded as well. So the jurisdiction that Fort Peck covers, large land base, but we have cross deputization. So we do have county, we have troopers that are cross deputized. So Montana Highway Patrol. We have the drug task force, and we have city, Wolf Point City tribal officers. We don't have any BIA. We're 638'd. So we have, and maybe some of you have seen this argument recently, but we've had the cross deputization argument that it was unconstitutional, but it was upheld, and that's been recently in the news locally, but it's in the circuit court. So a lot of other people are looking at that. And this is one of the things that we try to talk about as well, is the cross deputization and how that works. And Fort Peck is in favor of it. But, you know, even with situations where child welfare is involved, you know, we have a unique situation with that as well at Fort Peck. Right now, the tribes recently 638'd the EIA portion of social services. So they're in a transition, and it just took place on October 31st. And we do have an agreement with Child and Family Services. So Child and Family Services, they do the cases. How it operated prior to the 31st is Child and Family Services would handle all of the children that were not fully enrolled, and BIA would handle the children that were fully enrolled in any jurisdiction, any federally recognized tribe. So now that the tribes are taking over, they're still restructuring it, but Child and Family Services is still a big part of our child welfare program. And ICWA cases, we have our, I don't know if we have anybody on from Fort Peck right now, if Ingrid's on, but Ingrid is our ICWA contact for Fort Peck. And we also have our ICWA attorneys, and we have several, let's see. Somebody is knocking on my door. Sorry for that. So we have 4 judges, and going back into what we did last week, we went to a national conference. It's the NIJA conference. It's a conference that's held every year for the tribal judges throughout the nation. So one of the topics that they talked about was the Brackeen case in ICWA. And for those of you that aren't familiar with Kate Fort, some of you may know her. I've seen her. There's a good resource if you're ever interested in just reading Indian country opinions, laws, news, anything, Turtle Talk. And you just turtletalk.com. You can get daily emails. You can check what they have going on, but they send out daily information. And so Kate Fort is Michigan State. She works for the Indigenous Law and Policy Center there, and she is the ICWA expert. She's also one of the attorneys with the Brackeen case, and there's 4 tribes that had signed on with that. So she gave us a presentation. So what I'm going to do is basically recap some of the stuff that she had shared with us, because it's the most recent information for those that are familiar with ICWA. A lot of the issues that have been going on over the years. I don't even want to start too far back, but I heard the date of ICWA today, and I was thinking, wow, I'm older than ICWA. So it really hasn't been around that long, but it's been around long enough where we've established our foundation of why it's important to tribal nations. And when we think about, we've done a trafficking conference where we've lost people, and and families never see them again, and we wonder, we don't have any closure on it. But some of these children that we're losing, it's not because they want to go, it's because of placements, it's because of leaving situations that they don't want to be in, that they can't tell us about because they don't know how to contact us. And just recently, within the past couple months, we had a girl call us from California who just called everywhere in the tribe because she didn't even know who to ask for, got a hold of a lady here at the court and told her situation. And basically she was a runaway, but she was a runaway because the social worker in California was not comfortable removing her because she was an older teenage child, and they didn't feel comfortable removing her because they felt that although she was in a dangerous situation because there was drugs and violence going on in the home, that she was able to go to school and take care of herself. And the way that she had reported it to us, we're like, that can't be right. You aren't telling us everything. And so we end up getting her in contact with all the right people. She does get placed, but we find out that a lot of what she said, there was truth to it. So we're like, why? The investigator told us they didn't know how to contact. She told them about Fort Peck and where Montana was. She'd been here before, lived here as a little girl, but she couldn't tell them exactly how to get here. And they didn't know how to find out. How do we find this tribe, and what do we do about it? And luckily, I mean, she is in the system, but she's being well taken care of, and her schooling is back on track, and we know where she's at, and we know her family here, and her family knows where she's at because they said that the last they had seen her, she was taken to Great Falls. So somehow she ends up in California, and she was with a family member though. And I think that was the part that may have been a little confusing to some of them, because it was a family member, but an extended family member. And so they weren't sure. They asked us about ICWA and, what do we do for this? And so getting them the resources was helpful in knowing who to contact. And there is a lot of resources online, but for Kate Fort, do you ever have any specific questions or you want to know anything that she's working on? I mean, you can Google her and there's a lot of information there. One of the things that she had shared is with the Brackeen situation, the panel discussion was August 9th of 2019, and the tribes and the federal government they'd won on all the issues except for standing. So some of those issues were equal protection, commandeering, non-delegation, Administrative Procedures Act, and the dissent found for the states on the commandeering. The NBOC was granted, and oral argument was January 22nd. And so the NBOC, she talked about that, and and how it's this huge scary thing, right? And she was there, but she wasn't one of the ones arguing. But it was it makes a lot of people nervous, the attorneys, the tribes, all over Indian country, even those that are just working in social services, because of the predictability of what could happen at the Supreme Court. And the Fifth Circuit decision, the NBOC decision from the Fifth Circuit, was 324 pages long. And so within that decision, there, the attorneys felt that the judges were all over the place with a lot of the things that they were saying, without having a clear holding of what it is that they were focusing on. And they felt that it was confusing, it was hard to follow, and that they still made constitutional decisions within that 324 pages without the clear holding. So the three major areas that they believe the court will consider are the commandeering, the congressional power, and the equal protection. So the equal protection, talking about the political relationship of natives, and how the federal government views them versus, the equal protection. It's arguable that natives are not just strictly that political entity that Congress has used us as in the laws and the statutes, and that there is that equal protection that should apply to not just the natives, but also those the foster parents and the families that are caught up in the situations with ICWA, with the placements and the adoptions. And I guess the general feeling is that they're really concerned about Texas's viewpoint on it, and also what it is that they're actually going to take away from those arguments in November as far as Texas. And the questions presented to the court that Ms. Fort went over, and I actually have them here. So the questions that she had, and these are good just for you all too to think about, is does ICWA in general, or do certain provisions governing minimum standard placement preferences and record keeping impermissibly commandeer states? So that's one of the questions they feel for the commandeering. And for the equal protection, does ICWA in general, or do the statutes placement preferences or other Indian families and Indian foster homes violate equal protection? And so who is that equal protection covering? Is it just one side? Is it both sides? And has Congress exceeded its Article 1 authority by enacting laws governing child custody proceedings? And so the argument with Congress having the plenary power, right, to enact statutes and laws in regards to Native persons. And when you talk about ICWA, is it really a child custody situation? Is the question that they're afraid they're going to ask, because who gets authority over child custody? It's the states, right? Not the federal government. So what is the exception that's being made if you have the federal government making these laws and rules for a certain group of people, and what is the status of that people? So, there are some real arguments that can be made, and I think the fear is that ICWA will change no matter what decision comes out of the Supreme Court. It will change, but what does that change look like? And the hope is that it's going to be a narrow scope, and whatever is inside that scope can be worked with through the states. So some of the states have already implemented their own state ICWA laws. I believe Colorado is one of them. And I think that the states are moving on it. The couple that I've seen that they're essentially mirroring what the federal government has done a little more specific to what their state encounters. But I know Montana does not have an ICWA law right now, but they are, and I don't even know who they are. I know the law school is part of this, but it's the Montana Indian Family in Preservation Act. And I actually just got to see it yesterday evening. And I know that this legislation is going to be moving forward. It's being looked at. So for those of you that are familiar with it, if you want to chime in on it as well, but I know that it's going to form create the American Indian Child Welfare Advisory Council. And so this would be under Title 41, Chapter 8, Montana Indian Family Preservation Act. And there's a lot of, the reason why we have it is Judge Lily and I are going to go through it and look at it. And I believe they do have a sponsor for it already. So in conjunction with what is going on with the ICWA conference, I thought maybe they would have shared some of that information with y'all as well. But two more questions that I have that presented to the court. Does ICWA violate the non-delegation doctrine by allowing tribes to alter the statute's placement preferences? And so placement preferences is one of the issues that are brought up. Do the individual families have standing to challenge ICWA's placement preferences? And those are the questions presented to the court, those 5 questions. And it's going to be difficult to try to figure out what is going to happen with the justices when those when that decision comes out. So looking at the timeline, they believe that the decision will be by the end of June, so June of 23. So that gives the states a little bit of time to get any ICWA laws in placement that they feel would be necessary, that they would want. And, and for Montana, we have, 7 land base, and then we have Great Falls, we have Little Shell 8. I mean, we do have quite a bit of a Native population in Montana. And I know that some of the tribes are considered some of the largest tribes in the plains areas as well. And the petitions that were filed, the 4 intervening tribes, some of the tribes were there to represent what their take was on the Brackeen case. The United States filed, Texas filed, and the foster parents filed. But one of the things that Kate had mentioned is, those that had been following it for a long time, she used to call it the Texas versus Zinke. So these issues had, started and then it had taken on several names since then, to include Cherokee and Texas. And some of the more recent ICWA cases that she had shared with us, she had she follows them all. She tries to follow only the reported now because there's so many of them, but approximately 50 reported cases in 22 so far. So this was as of last month, and in 13 states, and that did include Texas. And the appeals primarily by parents. The tribes appealed 2 cases, but most of the appeals are by the parents. And she did reference Arizona. I think Tohono O'odham had a big case that I don't remember the facts of that one. And another one in Iowa with the Omaha tribe, that both of those were, they were wins for the tribe, but they didn't have, the facts weren't anything like the Brackeen case. They continued issues with inquiry, and there's a lot of resources for that, but I think that I'm not really sure how with ICWA itself, there's not a standard database that everybody uses. And that was part of the discussion as well. And they're looking at something, but not knowing how to get a hold and notify. And I believe there were 8 cases out of these 50 that had substantive issues attached with them. And a lot of it was the transfers that were going on or not going on, or that were unknown. So looking at, I think I shared pretty much all of the information that she shared with us in regards to that, but the contact information, those are things that we could send out if anybody has a listserv. We can send out that information for Montana, but also for other areas. And, there are some states that have a lot of, Washington State is one of them. They have a lot of procedures in place, for contacting people. But the Montana Indian Family Act, if anybody is interested in that, I believe that the law school might be the holders of the document. And I think I went over my time. I'm so sorry, but does anybody have any questions for me?
Well, we very much appreciate you coming today and sharing not only things about the Brackeen case, but fascinating information about what you do and the size of your reservation. I didn't realize it was that large. I guess, Brooke, Heather, you have your hand raised.
Thank you, Justice Gustafson. Thank you so much for being with us this morning, Judge Forstar. Yesterday, we talked a little bit, and also in June in our part 1 of the series, about collaboration between the state and tribes. And you have a really unique situation where clearly that collaboration is happening right away because the state social worker is working with BIA, as I understand, when we had the opportunity to observe court when we visited. And so do you have any thoughts that you wanted to share with all of the stakeholders on today about just the importance of that collaboration and the impact that you've seen that it can have on cases?
Yeah, with the collaboration, and sometimes it's hard for me to consider what other tribes have gone through, because we've always had a good relationship. I mean, yes, there are times the relationships are tense for whatever reason, but we always seem to work through it. And some of the other tribes that we had talked to, they comment on some of the, because just like any other, the politics get crazy, and social media gets crazy. But I think that the one thing about Fort Peck is we have people that have been in a lot of these positions of leadership, that it's a continuum of years, and we're not having that major changeover with legislators, people, director positions, and continuing that collaboration is including the people that we've had here. And even if they leave us, retire, we make them come back and tell us, like, what did you do about this? And how did you handle this? And keeping that communication. But like with the state, with our cross-step, with the Child and Family Services, we always want, and we bring in our attorneys too, and we tell them, this is what we want to see, and this is how we want it to happen, make it happen for us. And we're able to get, the stakeholders to the table. And I think that some people have had bad experiences, and I think they don't know how to get past that and have the resolve that they want. But we've been able to just call people to the table. But honestly, in my opinion, it takes one person. It takes one person to say, you know what, we're done with this separation, this division, whatever it is, and we're going to get together and we're going to get this figured out. And really, I think that's kind of what happens here sometimes too. We get off track, and then they need somebody to reel them in. But I would say, to not be afraid to ask questions if you don't understand. And there are cultural differences between all the tribes. And, they may get offended because you reached out to somebody without going through somebody else or an elder or a female or male, and it doesn't hurt to just ask somebody. And if they don't know the answer, I'm sure they can find out from somebody else. So, and I think that, knowing who in each tribe to reach out to, if each of us can give that information. And on the judicial side, we need to move better on that as well. I mean, we have the tribal Montana, Wyoming tribal judges, and it hasn't been active, but the Plains tribal judges have asked us to join them, and that reaches across North Dakota, South Dakota, Nebraska, and Idaho back over this way. So it's a large area, and this is the area that we cover for our national conference. So having somebody to be able to reach out to make those connections and then keeping in contact.
Thank you so much.
My crew is having fun back here because they have a wellness day. And every once a month we have a wellness day where they get to do fun stuff. It's during work time, but they get to do fun stuff and we feed them. So they're doing a game right now about learning your coworker, basically guess who or guess what. Everybody wrote down something, you have to guess who did this or, who said this. And I don't know what they're doing out there, but it sounds fun.
Well, we appreciate your time today. And well, Brooke and Heather, I know that you're up for the nuts and bolts part 2 with qualified expert witnesses and dispositions. And so I guess we'll turn it back over to you then, unless anybody has anything further for Judge Forstar.
Thank you. Panamia.
Thank you, Judge.
Thank you. Okay. Oops. That's okay. We're moving right along. So we're going to talk in the next hour about qualified expert witnesses and permanency options. And we're going to focus on guardianships when we're talking about permanency options. So with qualified expert witnesses, oh, there we go. So if you recall back to June, during the part 1 of the ICWA nuts and bolts, we started off with a discussion of tribal sovereignty. And I'm not sure if you remember this quote from part 1, but it was from a tribal chief of the Mississippi Band of Choctaw Indians. And that slide said, probably in no area is it more important that tribal sovereignty be respected than in an area as socially and culturally determinative as family relationships. And so that quote from part 1 came from the 1978 Senate hearings on ICWA. And that legislative history, if you take a look at that, also it's a pretty easy read and really gives a unique perspective on the history. But one of the particular points of concern, not surprisingly, because I think we're all familiar with why ICWA was passed, but was a failure of the non-Indian welfare workers to understand the role of extended family. So for example, in that quote that I have above, or that excerpt from the House report, it might have been, or Chief Isaac was talking about the misunderstanding of the dynamics of Indian extended family. And then below you can see an excerpt that discussed a misunderstanding of child rearing practices. And so in those Senate hearings, Chief Isaac testified that, quote, many of the individuals who decide the fate of our children are at best ignorant of our cultural values and at worst contemptful of the Indian way, and convinced that removal, usually to a non-Indian household or institution, can only benefit an Indian. And so obviously, when we talk about it in the qualified expert witness arena, the concern was that the courts were relying on social worker testimony, where the social worker really lacked in understanding and insight to determine whether a child was truly at risk. and not basing those decisions on bias and racism. And so following the 1978 Senate hearings, Congress codified that sentiment. And I think we've all read the part of ICWA that has the policy statements. And what it says is that state judicial bodies have often failed to recognize the essential tribal relations of Indian people and the cultural and social standards prevailing. And so Congress's solution was to require a qualified expert witness. So somebody who can come in and provide specific knowledge about the tribe's child rearing practices, obviously to curtail state court decisions based on bias. And so who can serve as a qualified expert witness? So there's a couple of different sources that you need to look at. So the ICWA regulations address this, and it says that a QEW simply must be qualified to testify. We call it the big question, Heather and I, and this came from part of our MCAN training that the AG's office does. But the big question is whether continued custody is likely to result in serious emotional or physical damage. So who can serve as a QEW? Somebody qualified to testify as to that big question. They must be able to testify to the prevailing social and cultural standards. And then the regulations further indicate that a tribe may designate a person as being qualified. And the regulations also indicate that a social worker on the case, so a state social worker, cannot serve as a qualified expert witness. However, a social worker who's not on the case can serve as a QEW. So Heather and I have had cases, particularly out-of-state cases, where the tribe might utilize one of their tribal social services workers to be the QEW. For example, I think the Puyallup tribe does that. It's interesting to note that the Montana Code Annotated in Title 41 also defines a qualified expert witness. And there's three categories under Montana law if you look at that statute. And it includes a member of the Indian child's tribe who's recognized by the tribal community and knowledgeable about cultural standards. That's certainly consistent with the ICWA regulations. The second category is a lay expert who has child and family services experience and knowledge of the prevailing social standards. That's pretty consistent. And then the third one under Montana law is a professional person who has child and family services experience and has knowledge of Indian culture, family structure, and child rearing practices in general. And so the Montana Code really mirrors the 1979 guidelines that also kind of broke out who can be a qualified expert witnesses into several categories. And so after taking comments for the 2016 rule, the regulations kind of narrowed that a little bit, or not narrowed it, excuse me, just made that a little bit broader and said, well, they obviously need to be able to testify to the big question.
So what role does the QEW play in state district court hearings? Last year, I can't remember when exactly, but there was a survey that a number of you participated in, and portions of that survey had questions regarding the QEW. And it seems that maybe some refreshers about what a QEW in our cases does was important. And so we wanted to make sure to talk about what that role is in our state district court hearings. So the QEW shares expertise, similar to the way that you would call another kind of expert in any of your criminal or civil cases, like a treating physician or an accountant or those sorts of things. So really, it's an expert who's going to talk about their expertise with the knowledge of the child rearing practices and the culture of the particular child's tribe. In The other role for the QEW, I think, is to educate the court with information that's beyond what a typical social worker would know. So if that has to do with the family structures, or like just now, Judge Forstar mentioned that you might accidentally call the wrong person at the tribe, or you might call a male tribal member about an issue, and really you should have called a female tribal member because that particular tribe is matriarchal. And really that QEW can educate the court on that kind of information that a typical social worker might not know about. And then, of course, as Brooke mentioned, the role is to assist the court in making decisions that hopefully are not tainted with cultural bias. So that can go back to what discipline might look like, extended family, all of those sorts of things that, numbers of people in the home, multi-generational families, and those sorts of things. So hopefully that QEW can help with that. The QEW does not act as the tribe's representative for the case. Certainly the QEW might have a lot of contact with the tribe, with the ICWA agent or with social services, but they aren't the representative for the tribe. So it's a separate inquiry as to the tribe's position on the cases, not the inquiry directly to the QEW. And then also, of course, the QEW does not replace the tribe's determination of eligibility for membership. So even though we are so lucky, Edie's in the room again today, and Edie knows everyone. And so she might know that, that someone is a descendant because she knows their aunties and grandmas. But without the determination from Northern Cheyenne, we would continue to treat it as an ICWA case, but her knowledge of the family doesn't replace the actual determination from the tribe's enrollment office. Okay. The scope of the QEW expertise is the knowledge of child rearing practices as they pertain to family organization and child rearing, and then also those prevailing social and cultural standards and child rearing practices. But again, importantly, the QEW is not giving opinions regarding ICWA compliance. So we'll talk a little bit more about this when we talk about the practice tips for judges. But while the QEW is certainly providing a lot of information to the court, they are not reporting on the whether or not the state has met its legal burdens. The BIA guidelines wrong part. Sorry. It is important, I think, to make sure that in court, even though things can be a little squishy when you're having QEW testimony, that the court is the one making those compliance findings. I know I sort of said that, but.
So let's talk about when QEW testimony is required. The statute is pretty clear, the ICWA statute, and it is that no foster care placement may be ordered and no termination of parental rights may be ordered. Absence of determination and supported in a foster care placement, we all know that's clear and convincing. And with termination of parental rights supported by evidence beyond a reasonable doubt, including that testimony of the qualified expert witness as to that big question, right? That continued custody of the child by the parent or Indian custodian is likely to result in serious emotional or physical damage to the child. If you take a look at some case law in Montana, I think what's really important to remember about the actual testimony is we need the QEW to either be saying those words, or as a county attorney, we need to be phrasing the questions using those magic words from the big question, right? And so the continued custody is likely to result in serious emotional or physical damage, not just is continued foster care placement or as termination of parental rights in the best interest. Certainly that can be one of the questions, but the QEW needs to testify specifically as to the big question, or that is going to create an appealable issue. So when we talk about foster care placement, what does that mean? Well, where you look in ICWA is it's included in the definition of child custody proceeding under 1903. And foster care placement means an action where the child is removed, and that can be from one or both parents or an Indian custodian for temporary placement in a foster home or institution, and where the parent cannot have the child returned upon demand, but where the parental rights have not been terminated.
Okay, so practically for us in Montana, under Title 41, what do those foster care, child custody proceeding or foster care placement hearings mean? So of course, we have our show cause hearing at the beginning. We have the adjudication and disposition, and then the the termination of parental rights, the TPR. Also, anytime that a child has been home in a trial home visit and then is removed, so an out-of-home placement hearing, that testimony would also be required. So any of these ones with the asterisks are required testimony for the QEW. Best practices would be that testimony is also provided at the extension of temporary custody hearing and in a guardianship hearing, which makes sense when you think about particularly in an extension hearing if children have not been returned to parents' care. And also, depending on your jurisdiction's frequency with which you hold status hearings, if there has not been that testimony for 6 months about why a child needs to, if the child is still at risk of serious emotional or physical damage, it really goes with the spirit of the ICWA, where we are saying to the court, we are having this QEW testify to the fact that this child would be at risk, and that under child rearing customs and practices, they are not safe to be returning home for whatever reasons. So I think that really, even though that's not required, we really would recommend that testimony be provided at those additional hearings. So now we're talking about the big question. And as we've mentioned now a few times, the big question is, if the child remains in the home or is returned to the home, will the child likely suffer from serious emotional or physical damage? And if the qualified expert witness cannot testify to that, then the child should return home or stay in the home. And we really wanted to point out that the comments to the regulations are clear that this does not require a risk of death or serious bodily injury. This phrase does encompass the child's health, safety, welfare. I think the comments are very clear that we're not trying to place Indian children at risk of death before they're removed. And actually, when Judge Forstar was mentioning that child in California, I do think that sometimes that's tricky about if the department has met that standard to remove a child from the home. But I think that takes a lot of collaboration and figuring out how you can best put safety measures in place. And so anyway, it does not require that level of risk of harm.
Okay, so steps to qualify a witness. So if you have a case in a jurisdiction in which the QEW has never been qualified or has never testified, it's a really great opportunity, and we need to be introducing the witness to the court and to the parties. As a best practice, if the witness does have a CV or resume, I would suggest sending that out to the parties before the hearing. I have actually offered, if counsel had additional questions even before we get into court with a new witness, that we could set up a telephone call so they have an opportunity to meet, because again, and we're going to talk about this later, but the QEW is not the state's witness, is not a hired gun per se, and we want to make these cases, we don't want to be adversarial, and we want to be collaborative. So I do think it's important for all the parties to get to know the QEW. For example, when we did a QEW training in Great Falls about a year ago now, one of those individuals who took the training was qualified then in a case I had in Musselshell County. And it was just a really great opportunity for him to share all of his background and experience. Obviously, the ultimate foundational question is actually that last bullet, right? That they have knowledge of customs and traditions related to child rearing, and or that the tribe has designated them as being a witness for the tribe. So depending on the individual, maybe their background is also relevant and their work experience. Edie mentioned yesterday that she had, 30 years of child and family services experience with the BIA and also working directly with tribes. This Blackfeet QEW, Clifton DeRoche is his name. He's wonderful, by the way, if you have a Blackfeet case. He worked at the immersion school. And so obviously that is very relevant in terms of his experience and understanding family structure and culture, language, traditions, all of that sort of thing. And Heather is looking at a comment. Is anything you want to address or?
Well, I'm going to address the first one, but Brooke, this question is coming from Jessica Finley at, I believe, Missoula County. ICWA is clear that a foster care placement may not be ordered without QEW. However, 432 doesn't match ICWA's language and states only if a proceeding under this chapter involves an Indian child, a QEW is required. This causes confusion in our cases. Is it required only for foster care placements outside the home, or is it required in cases where CFS never removes a child but is seeking intervention and something like TIA?
So if you go back to the Title 41 slide, the asterisks represented where those specific statutes specifically mention that qualified expert witness testimony is required. And I hear what you're saying about that 432. I think it's subsection 8. It talks about in this chapter. And so I think obviously at a minimum, we need to be having that QEW testimony during those hearings where the statute specifically requires it. Because of that 432 sub 8 that you're referencing, Jessica, and what Heather was talking about, the spirit of ICWA, I think it makes sense to have that at XTLC hearings. I think it's pretty clear that it's required at out-of-home placement hearings when we look at that definition of foster care. That's removing the parent, removing the child from the home. So if they've been on a trial home visit and they're unsafe, clearly that's required. Because it's in the show cause statute, I do think it would be required at that point as well.
What if the child is never removed from the parent's care, was the second part of her question.
Then I don't think it would meet the definition of foster care placement.
So that's how we treat that question, Jessica. Brooke and I here, I don't get the QEW testimony when children are still in the home. So,
and I think if we look at the legislative history and just thinking about the purpose of the QEW testimony, it's so that the court is not making a decision about whether that out-of-home placement is appropriate. And we want to make sure the court's making that decision that is not based in cultural bias. And so if the child is home, then I'm not sure that is, well, I am sure, I don't believe that is needed given the legislative history of, why we use QEWs and also the definition of foster care placement.
I do think that sometimes that phrase continued custody when the department has legal custody of a child can be absolutely, that has tripped me up. Just generally, I don't provide that testimony when kids are in the home because of everything Brooke just said. So, okay. So, you're next.
Okay, so let's talk about some practice tips. I think I kind of referenced this earlier, but really important to work collaboratively with the QEW A lot of times, not always, but a lot of times the QEW is going to be a member of the child's tribe. Hopefully, one of the goals that Heather and I have is that if possible, with our continued QEW training, that we're always able to use a QEW from a member of the child's tribe with that specific knowledge. But because of their background and the people they know and their familiarity with the communities, I think it can be really beneficial for the families we're serving to build that relationship with the QEW. And that's not just for social workers. I think that would be important for defense counsel as well. I think Courtney Bagnell-Moorhead talked yesterday about the benefits of parents and defense counsel building that relationship with the ICWA agents, but I think that's equally true for the QEWs. Really important to invite the QEWs to family engagement meetings. They can often have really important insight or recommendations, or oftentimes just support for the family. I've seen that where there's, you know, when there's another, it's not always an Indian person, but if the QEW is a member of a tribe, it's nice for that family to have another Indian person in the room giving some positive words of encouragement. Practice tips for attorneys. The regulations do talk about this. Best practice is to consult with the tribe for preferred QEWs. In Montana, I think most of us have pretty close relationships with the tribes, or we're familiar, you know, we know that if it's a Northern Cheyenne tribe, you know, at least in this region, that we're going to use Edie Adams. We know if it's a Crow case, we're going to use Carrie Covers Up or Skeeter He Does It. So, but if you're less familiar, especially for some of the out-of-state cases, that should be the first phone call as an attorney that you're making is with the ICWA agent to ask if they have a preferred QEW. One thing I think that's important to note, I think attorneys probably all know this, but not all social workers do. It's not the job of the social worker to secure the QEW. However, upon making that initial contact in June, we talked about the importance of building that relationship, you know, right away when there's a removal of the child. Certainly during that first contact, a social worker could ask, if they think of it, do you have a list of preferred QEWs? But ultimately that is the job of the attorney. And then DPHHS does have a website that Carrera Pretty Paint keeps updated, and not all of those individuals have been qualified, but they have, all of them have taken the QEW training.
So Kelly's question went to something that Brooke just mentioned, which is evidently there have been a county attorney or two who has indicated that the QEW is their witness and that the defense attorney is not allowed to talk to them. Clearly Brooke and I completely disagree with that. While it is the state's expert in that we consult with them, we elicit their testimony, they're not a hired gun. And just like with any civil case, opposing counsel is allowed to take depositions of experts and all those sorts of things. In our cases, they're much more collaborative. I don't see any reason why defense counsel isn't able to talk to a QEW. It should be that we're figuring out whether or not children can safely return to parents' care. I really think that that kind of staffing is very important. I guess if there is a really contentious case, in answer to your question, Kelly, I can see why a county attorney might want to be present during that conversation. But I think that that witness is really an important part of, yes, they are the expert for the case. But just meaning their opinion isn't necessary. It's just like with any car accident expert or reconstruction expert that you might hire, that you would say to them, oh, aren't they the expert for the case, not the state? Well, it's a little tricky because it's the state's burden. The state pays the QEW. So I hear what you're saying. They are the qualified expert witness for the case. I guess what I would say is, if for some reason the QEW felt the children were not at risk, but the department did feel they were at risk, that would really be a difficult hearing, right? Where we'd have to either figure out, is this witness going to be our witness? Is this witness going to be the defense's QAW? But
And practically speaking, we're going to be resolving those issues outside of
Yeah.
court in a collaborative nature.
Oh, and not being an adverse witness. Okay, thanks, Lisa. I guess I just want to say, I think that QAW really is a resource, and I just would encourage, if there are county attorneys who are feeling prickly about that, to kind of examine why that is and what's concerning them about Parents Council talking to a QEW. I think the more information a QEW has, the better their testimony is. So, and then the QEW certainly is going to tell the county attorney. I talked to mom's attorney, and she said the following. And so now I'm not sure about my testimony. What's going on? I mean, all of that is information sharing. So I think that, participating in those discussions is just really important. So I don't know if that helped answer some of those questions. And then going back to the judge's tips, that the QEW should not be testifying about legal conclusions. As I mentioned, the QEW can't say, yes, the department has complied with ICWA. That's not their finding to make. It's the judge's finding to make. We also would ask that courts keep in mind that QEW testimony by alternative means is certainly helpful and important. We talked about this yesterday, how, appearances by Zoom for tribal members and for ICWA agents, and then also for QEW, I think is super important. And then we also wanted to say that, the court needs to make that finding on that big question that a child is at risk. But also that doesn't need to be the only limitation to the QEW's testimony. As we mentioned earlier, educating the court on the child rearing practices and whether or not, for example, the family structure in which the child's being raised is appropriate, and whether that fits that particular family's needs.
And I think the other thing for judges to keep in mind is that when they're making a finding that continued custody is likely to result in serious emotional or physical damage, the QEW testimony just has to be one part of that finding. But certainly they can, their findings can rely on additional testimony, but it must include the QEW. Okay, so we're going to talk about permanency options now. So if you look at Montana's permanency statute, these are the options that we have under Montana law. Obviously, our number one goal for all of us is reunification, and that could be with a parent, guardian, or Indian custodian. Another permanency option under Montana is the placement with a non-custodial parent. We refer to that as the SS. That's going to supersede any existing custodial order. We have long-term custody that hopefully is used pretty infrequently, where the child is of the correct age, adoption, and guardianship. So this isn't a training where we're going to be focusing on each permanency option, but rather, since this is specifically in ICWA training, we're going to be focusing on guardianships. Why are we focusing on guardianships? Because what we know from our tribal partners is that it is the preferred permanency option, and that it is a culturally appropriate outcome when reunification is not appropriate. That is not to say that termination is absolutely never used, or that I've never been involved in a case where we had termination of parental rights. But those are at least in my practice and Heather's practice, those are very few and far between, I think, just based on that relationship that we have with our tribal partners. For some tribes, If you listen to podcasts or, read Turtle Talk or any other, Indian law resources, you're going to learn that some tribes don't even have a word in their native language for adoption. And that makes sense because it's not consistent with many tribes' culture. And so customary adoption is where there's a transfer of custody without termination of parental rights. So this is something that you may see in tribal codes. You may see parental of termination or termination of parental rights, but you may not. And what you'll probably see are these customary adoptions. This is what most closely aligned under Montana law with adoptions. This is really exciting to me that there are two states that I'm aware of, California and Oregon, who have actually incorporated tribal customary adoptions into their state statutes. So these, in California, this was passed in 2010. In Oregon, it was passed just last year. And so it allows for traditional tribal adoptions to be recognized by state courts. And so these statutes also have consultation requirements between the state agency and the tribes. And what happens is that it's the tribal court that actually completes the customary adoption. And the state courts give full faith and credit to that tribal adoption and actually issue a state decree. And so if you want to do some reading on that, it's really great. There's some information about Oregon statute where the state agency is indicating that their additional requirement of adding ongoing requirements for cultural connections, where a guardianship has absolutely improved that collaboration between state and tribes and active efforts for the department.
We did want to briefly talk about the legal differences between adoption and guardianships. And I think starting out importantly, the standard of proof in termination of parental rights is beyond a reasonable doubt. That's higher than in non-ICWA cases, as you all know. That's the highest burden that we can have under our state court systems. And that also makes sense that that would be the case given the reasons behind the ICWA. Brooke and I, it is really interesting that under guardianships, it's not set forth what that standard of proof is. I think that that's kind of an interesting part about that final disposition. Typically in practice, I think that clear and convincing evidence is really what it comes down to, that the judges expect you to have it at least that level. But I think that's really an interesting
Oversight.
yeah, for sure, oversight. Okay, so the best interest of child is what our BIO stands for. So under the termination, that the termination of parental rights has to be in the best interest of the child. And under guardianships, it's the termination is not in the child's best interest, or that termination has been granted, but adoption is not in the best interest. So it's kind of a negative way of phrasing it. Termination would not be in this child's best interest is the primary time under which guardianships are granted. Usually parental rights are previously terminated. Under adjudication, does that have to occur prior to that final disposition? Under termination, sometimes there can be instances in which a parent has relinquished or so you haven't gotten to temporary custody, but right away or at permanent custody. And then under guardianships, yes, there has to have been an adjudication. And then the other requirements for termination or other ways in which you would get there would be relinquishment, abandonment, failed treatment plan, and unlikely to change, and that active efforts have been successful. Those are just the primary things that we of course see in terminations. There are the other circumstances that can come up, but those are the primary ones where parents have relinquished, or that there's a failed treatment plan and they're unlikely to change within a reasonable time. And under guardianships, the requirements would be that the guardian provides a family-like setting, that they're committed to long-term relationships, there has been active efforts, and that those efforts are likely, further efforts are likely unproductive. I think that's an important finding under guardianships.
So then we have a difference between TPR and guardianships when it comes to revocation. So with respect to revoking an adoption decree under ICWA, what the regulations say is that within 2 years of a final decree, that adoption can be revoked, but only by fraud or duress. For guardianships, we know under 444 that a court can revoke a guardianship, but there are going to be certain requirements, obviously. The judge can do that if continuation of the guardianship is not in the best interest of a child after a hearing is held. A lot of times when we're talking about TPR and guardianships, you'll hear discussions, of course, about the 15 out of 22, right? So when a child has been out of the home for 15 out of the last 22 months. And of course, there's a federal definition in how you need to calculate that, but that it's the presumption is that it's in the best interest of the child to terminate parental rights, and that the petition, a petition must be filed unless there are certain exceptions. So if you look at the 603 under Title 41, it talks about, and if you look at federal law, it talks about what those exceptions are. With guardianships, oftentimes we're operating if the child has, for exceeding that 15 out of 22, one of the exceptions is that they're being cared for a relative. Now, of course, that doesn't always happen. And as one of our tribal panelists was indicating, Kathy Boss-Ribs, that, they're trying to find a lot more tribal foster homes. And so, of course, we have cases where Indian children are with a non-Indian resource home. And so what are we operating on then for guardianships when they're not with, the child is not with family and we're past that 15 out of 22 months? What I do in petitions is also rely on a compelling reason for not filing. And the compelling reason is really that this is an ICWA case. And in our cases, because we do have that consultation, as in every case, in every jurisdiction, the state should be consulting the tribe, but that when we're filing for guardianship, it's because both the state and the tribe have agreed that guardianship is a culturally appropriate outcome for this child. And of course, when we're thinking about, the whole reason for the 15 out of 22 rule and our permanency hearings is we want to make sure that children are not languishing in foster care, right? And so another compelling reason could be that with guardianships, we are achieving permanency faster. So with respect to the revocation though, who can revoke? Under ICWA, we know that it's the parent, Indian custodian, child, or tribe. That's explicitly stated. In our guardianship statute, a lot was overlooked, unfortunately, and so it's not set forth. But practically speaking, we know that it's probably going to be the parent or the guardian or Indian custodian. It could be the child. Maybe some of you out there want to put in a chat if you've ever seen that. We put maybe if over 14, because we know Title 72 doesn't apply to our Title 44 guardianships. However, for Title 72 guardianships, the statute does allow a child to be a petitioner if they're over 14. So the statute is not, like I said, explicit as to who can petition, but it simply indicates that the court may revoke the petition after a hearing if continuation is not in the best interest of the child. And then as to notice, the statute simply states that the moving party must give notice. So it doesn't say specifically who the moving party can be, but it We do know that notice has to be given to the guardian of the child, the guardian ad litem, if one is appointed, to the department, to the child's parent, and then other persons directly interested in the welfare of the child. And in our guardianship decrees, we specifically list the tribe, even though the tribe is not specifically listed in 444 sub 6. Clearly, the tribe is another person directly interested in the welfare of the child and would need notice if a petitioner was moving to remove or revoke the guardianship. Now, 444 also provides that a guardian obviously may petition to resign a guardianship. And what the statute says is if proper notice is given and after a hearing, the court decides that resignation is appropriate, the court can appoint a successor guardian or can terminate the guardianship and restore temporary legal custody to the department. I think Heather's going to talk a little bit more about that in one of our upcoming slides. Name change. Also, we're gonna get into this a little bit more later on when we talk about some of the concerns people have about guardianships. Under ICWA, or not under ICWA, excuse me, but under state law, after adoption, yes, the adoptive parent can change the name. With a guardianship, Title 27, Heather? Yeah, Title 27, and looking at that statute, you must have the consent of at least one of the parents. What Heather and I have heard is that there are some jurisdictions in which the court is allowing name changes for children after a guardianship has been entered. And our interpretation of Title 27 is that that would be incorrect and certainly not within the spirit of ICWA and keeping kiddos connected to their family and tribe and communities. A QEW testimony needs to happen at both TPR and guardianships.
Mick had a question that, Mick, I'm gonna have Brooke get to that at the end if we have time regarding more appeals in California. I'm gonna keep going on our slide, but we can circle back to that. So when we talk about guardianships, I think that it's just important that, like, let's just get real, that we have some concerns that we hear often from parties during our cases. And primarily the concerns Brooke and I hear, and I'm sure all of you hear these same ones, are concerns over future litigation, changing the child's name, ongoing family contact. And then we also hear things like guardianships can be detrimental to children. And, you know, they're too young. If they're little ones, guardianships last too long and then they're detrimental. And then finally, that guardianships are not as permanent. We definitely have heard those. And so we're going to go over all of those concerns. The first one of a guardianship may expose a caregiver to ongoing litigation. So I think it's really important to mention that guardianships are not easily undone. As Brooke just mentioned, we have to have someone petition the court. There has to be a hearing. Notice has to be provided. Notice has to be provided to all of the people Brooke just mentioned. And then there has to be a hearing on whether or not that is in the best interest of the child to dissolve the guardianship. Further, if it was dissolved and people were not in agreement about what should happen next, likely temporary custody to the department would be reinstated. So I really want to say that in my 12 years of doing these sorts of cases, and in Brooke's 12 years of doing DN cases, we have not had a case in which a parent's petition to dissolve a guardianship was granted over the objection of the department or a guardian. So I realize we can't prevent people from filing petitions to dissolve guardianships. And so certainly there can be litigation that happens, but I also anecdotally, these petitions occasionally that I've seen have been in non-ICWA cases with family members. And I really want to stress that while, yes, people can file that petition, they also, 2 years after an adoption, could file a petition to revoke an adoption based on fraud or duress. And so the likelihood of litigation really I see is similar. And again, a high burden. If a guardian doesn't agree that dissolving the guardianship is in the child's best interest, it's really unlikely a court is going to agree that it's in the child's best interest, because that guardian would have been providing care and custody to that child for whatever period of time that would have been. Also, given that the finding under guardianships is that the active efforts would likely remain unproductive, you'd really have to see that a parent has fully rehabilitated themselves and that the dissolution of the guardianship is in the best interest. And that burden, I think, is very high for parents to reach. And most likely when you see guardianships being dissolved, it's because a parent and a guardian have agreed and that it's time for a parent to resume care and custody of their child.
Okay, the other concern that we hear from parties when reunification is not successful and there are discussions about TPR versus guardianship is that the resource family is not going to be able to change the child's name. This is probably, we could spend an entire afternoon just talking about this. And I think it's one of the most important points to address. I think it's an opportunity for compassion as either you're a CASA or the social worker, and maybe you're hearing this from the resource family. I think it's an opportunity to say, I can understand how that might be concerning for you, but let me help you to understand why it's really important that this Indian child's name remain intact. We heard from Crescentia So yesterday. I love this quote when she was talking about their names. This is how we learn who we are. And she talked about that kind of being a window into the world for Indian folks. At the beginning of today, we saw that awesome video of children from around the state of Montana, tribal members. Riley Singer, from Crow, introduced himself with who his clan is, the Greasy Mouth clan. And that is absolutely critical to an Indian child's identity, right? A child's name is going to maintain the connection to her family, culture, and tribe. What I hear from tribal partners is that what is the first thing that an Indian person asks when meeting another Indian person? What's your name? Who's your family, right? And because that just tells everything for Indian people. And so really important that child's name remains intact. One of the things Heather and I talked about is, if after explaining that importance to a resource family, if they're not able to understand that, I think an important question might be, is that guardianship then in the best interest of that child? Ongoing family connections. Another concern that we hear is, well, the family is going to harass me, or will I be required to maintain those connections? I think an important point is that if that is going to happen, it's going to happen regardless of whether the legal designation is an adoption or a guardianship. The legal designation is not going to change whether family members are safe or unsafe. And so we know this is a concern, we hear it, and how do we address it? I think it comes back to educating the stakeholders involved, including, of course, the resource families. We need to make sure that resource families understand that maintaining healthy connections to parents and an extended family is absolutely critical to the long-term best interest of that Indian child. We know that ICWA is the gold standard, and we know that not just in ICWA, but in all cases, the research shows that kinship placement is best practice in child welfare, period. And so again, going back to that amicus brief of former foster children, the connection to family for an Indian child is critical, right, to a tribe's current and future generations to maintain and teach their customs and history.
So one of the other things that I did want to mention with the ongoing connections with family is that does provide an opportunity during the course of the case for social workers to really work with the resource family and really work with the biological family to see how we can create sort of organic relationships between them. I think we most often hear that question about ongoing family contact when it's non-family member guardianships. And so if you have questions about how to be creative about that, I think that family engagement meetings are a great time to discuss that. Another concern that we hear are guardianships are detrimental to children. There have been a number of studies regarding guardianships and permanency outcomes for children that have been rural studies that also include Montana in some of their findings. And this was a study of subsidized guardianships by the Children's Bureau under the U.S. Department of Health. And what they found, and so you can see that we've highlighted in here that Montana was part of these findings, that there really is not a statistical difference between adopted children and children in guardianships regarding their stability, well-being, school performance, safety, engagement, and risky behaviors. And that also that children and caregivers, as you can see in the red pen highlight, is that they show an enhanced well-being due to greater sense of autonomy, permanence, stability, and have greater involvement in recreational activities, sports, religious and cultural events, which makes sense if they're under a guardianship and still have their name, right? The next concern that we wanted to bring up is that guardianships are not permanent. So this is a Montana Supreme Court case. And again, based on those findings in the Children's Bureau study, Justice Gustafson quoted that research suggests permanency is more closely tied to the child's relationship with his or her placement than the legal designation. So children really, and if you guys go to that study, it really does find, and that's from 2011, which I think then to still in 2022 be talking about whether or not guardianships are permanent enough. I think we just have to keep having these conversations and be really clear that for children, it's not that designation of I was adopted by my grandma, but instead that I'm being raised by my and so I think that the importance of that relationship for the primary caregiver as opposed to the designation. I just want us all to keep that in mind. And that also, again, for these children and caregivers perspectives, and this was a 4E study. This one is a slightly, oh, it was the same one. This was a particularly desirable outcome. And then it mentions communities in Montana, Minnesota, and Oregon, because that is culturally appropriate. And that I love hearing from this youth in Montana that once a guardianship was initiated, that the child doesn't have to move anymore, that's permanent, that they didn't have to continue to have nightmares about court proceedings, and being worried that they might not have a normal childhood. We also, the state of Montana has done studies on the permanency outcomes and the length of time to permanency for children. This is all statistics and data that was collected by the department in the state of Montana from July 1st of 2014 to July 30th of 2020. And that during that time, there were 882 guardianships and then approximately 1,700 adoptions. That the average time to care prior to the finalizing of a guardianship was 766 days. The average time in care prior to finalizing, I'm sorry, that is a typo. It's finalizing adoption on that second column. That's what that one should say, of the 1,000 days. And then I think this is the fascinating part about permanency, that over those 6 years, that 47 children that were of those guardianships came back into care, and that 43 of those did not return to the guardian. So essentially, there was under 5% of failed guardianships. And then under the adoption, there were 90 children who came back into care during that time, with 68 of those children not returning to their adoptive home, which then is just under 4% of failed adoptions. And so we really wanted to point out that that is less than a 0.9% difference in the failure of that permanency option of children who then return into care from those finalized permanency options. I think that that's really important to see that, and I recognize that that might not entail the dissolution of guardianships that were all agreed upon and granted, but that number is so insignificant when you think about the potential of a failed permanency outcome. So I think that might be some information that you could share, with prospective guardians, with extended family, with foster care placements, or during foster care trainings, that really the permanence of those guardianships is nearly identical to the adoptions.
So coming around to compassionate practice, we've talked a lot about ICWA being the gold standard. And so I don't think we can really talk about that without recognizing that compassion is or needs to be part of the work we do. And this is just a great quote from that article, that it can be a powerful antidote against hopelessness. And we know that when people have hope, that they're able to heal and make change. So the return, just some final thoughts. The return on this investment is worth it. ICWA is the gold standard in child protection. And in June, we talked about compliance with ICWA is absolutely a must, but equally important is just understanding the spirit of ICWA. And so I just want to thank you all for the difficult work that you all do and for your willingness to spend these 2 mornings with us. I think anytime that we're willing to humble ourselves and learn from others, like we did from the amazing tribal panel, and like I know we're going to do with the great parent panelists, I think we are allies of ICWA in that way. And so thanks for allowing us to share all of this information. I'm sure I'm no different than most of you in that I love the work that I do, but it can have its ups and downs. And I think it can take a toll on all of us. And so I just want to share that delving into this research about compassion was really inspiring. And, including the research that compassion can strengthen our capacity to sustain this meaningful work that we do. Opportunity exists for all professionals. So there was a study cited in that article that indicated that physicians missed 80% of over 300 opportunities to show compassion over 8 appointments. And so when we correlate that to child welfare, we might ask, how are we going to do any better? And the good news is that because there are so many opportunities to show compassion, we can try again tomorrow. So as Judge Souza often says to our drug court or family recovery court participants, when they haven't quite met all of their obligations for the week, you'll have another opportunity next week. And so I think we can keep that in mind and give ourselves some grace in that way. Small changes lead to better outcomes. It can be so inspiring when Heather talked about the Arizona conference, but it can also be overwhelming. Oh my gosh, that we have so much work to do and so much that we want to do, but we know that small changes lead to better outcomes. We talked about just those small changes we can make in our body language or our language. Small changes, or excuse me, if we help one family, it was all worth it. And please let us know if you have any questions or we can be of assistance in the future.
So now, everyone, we're really excited. There is a parent panel that we are going to have that Kelly Sim from Casey Family Programs is going to facilitate. And just like Brooke said, we really appreciate you all attending today. And I'm really excited to hear from Chase and from Kyle. This is exciting to hear from the two of them. So Kelly, we are done.
Thanks, Heather and Brooke. Good morning, everyone, and good morning, especially to our parent panelists today. We do have a third parent that will be joining us. She let me know that she's running a little bit late. She is taking time off of work to join us this morning. So hopefully we'll have Kevin and Julie kind of be on the lookout for her as she joins later. But for now, we'll go ahead and start with Chase, and it's not Courtney Bagnell Moorhead. Some of you know that's not Courtney. That is Kyle Spain, who is joining us today. And so Chase and Kyle, I just want you guys to know that you are among friends. You are among, especially for some of us who have gotten to know you, a fan base. You have a fan base here. So, so if you'll feel comfortable as you can to just kind of share your stories, right? Share what you've learned, what you've experienced, any kind of, encouragement, challenge to us as the child welfare system that you have, any ideas that you might have to share with us. We are all ears for you today. So welcome again. And it really goes without saying that your stories, your experiences with the many agencies that are represented here, and your unique voices are really important to transforming our child welfare system. And to that end, we also want to hear specifically too about your heritage, culture, family values, and traditions, or anything of that nature that helped you get through some of these really difficult times in your lives. And so we'll just kind of be talking, freely about all of that. I'll start right now with Chase. Good morning, Chase. And he's taking time off of school. He's in college right now, taking some pre-med courses. And so I really appreciate you taking time off to be with us here today, Chase. If we could start with you, would you just say a little bit about your story, kind of who you are, maybe also with your tribal affiliation, your experience with child welfare with each of your children, and kind of where you are now?
Okay. Yeah, I can do that. And it's privileged to be here. I was just wondering if everybody can hear me okay.
Yes, I can hear you just fine. Thanks, Chase.
Okay. So my name's Chase Perot, and I have 3 children, but I am in a partnership, so that brings another 2 children. So I guess altogether I have 5. I live in the city of Billings, and most days I'm at college studying, and there's a lot of stuff to do with the kids that keep you pretty busy. So my experience with the welfare system, I had 3 cases starting in 2010, going up to the latest in 2018. And I did successfully complete the family drug court. And the kids are placed with me now. I've been sober for over 4 years. And like she mentioned earlier, I am in college for pre-med. That's kind of challenging, but there's also some cool things because we're a whole household of students now. And yeah.
Yeah. Thanks, Chase. Could we just take a moment to celebrate 4 years of sobriety? Does everybody have the little icons for celebration or just a hand clap? That's awesome. Thank you so much for sharing that, Chase. And when your children were removed, who who took care of them? Where were they placed?
All right, so I believe the first and second times it was a regular foster family who we didn't know.
Mm.
And this last time it was with kinship. So it was with my ex-wife's grandparents,
Okay.
and they're all part of the same tribe.
Okay. Awesome. All right. Before I go on to a question, I'm just going to go to Kyle right now and just kind of ask her to do the same. If you could also share your story, kind of who you are, your involvement in the child welfare system, and kind of what you're up to now.
Yeah. Hi, everyone. Good morning. I am the mother of 5 children. I live here in Billings. I am currently a part of the ICWA Family Recovery Court, which is Sousa. Say that. I had 2 cases, one with tribal court, the tribal social services in 2005, and my grandma had guardianship for all the years until my daughter's 17 right now. I didn't I got my second case in with CPS here in 2021 when my son was born due to my drug use. And he is currently with me now. I have joined the ICWA Family Recovery Court in October of 2021, and I have finished all of my treatment. And I just utilize all the resources, and I truly am blessed to be a part of the court, and just it saved my life. It really did.
Thanks, Kyle. Thanks,
Mhm.
Kyle. If I could go back to Chase and ask our first question, kind of what do you think was one of the most important factors in your recovery process and reunification with your children? Like, what was that tipping point for you?
There was a lot. It's hard to say any just one thing, and definitely the difference of joining a recovery court made a lot of difference just because of the support. And there is a lot of support there. So initially for me, just even joining, I wasn't really walking a good path yet. And they helped me distance myself from situations that wasn't really healthy or working for me at the time. And when I did get that distance by complying with the court, I was able to see the bigger picture of things. And there was also, the judge who was supportive. There was also a therapist that I got in with right away. And the court, they had an idea this person would work great for you. And they really did, because they kind of gave me a mental structure to work off of, because I did, come up against challenges, and they were experienced with exactly what I needed, really. So I was able to, you could kind of almost, say, well, I can see this would be a problem, and here's a structure, but the choice is really yours too. So I was able to, see the bigger picture and make the best choices, as well as even the treatment coordinator at the time. They were really supportive. I remember part of our phasing was we had to go and speak at some type of event, and it just so happened to be the McGuire conference for me, which I attended, once previously, and just so happened that my mom also attended that because she's a nurse. so she got to hear me speak, but I was nervous even doing that, and I went to the coordinator at the time and I said, I'm really uncomfortable doing this because I've been charged with PMFMAs in the past. And he said, well, you're absolutely the person who needs to go and speak because it shows that change is possible. And I was able to change my perception a little bit and go and, really share my experience with the family drug court at the McGuire conference. And that was, a growing experience for me, as well as even, having a sponsor, just a lot of things that I believe perfectly lined up together for me.
Yeah, Chase, I love what you're saying about the support that you receive from a whole variety of people, right? The recovery court, a judge, a therapist, a sponsor. And you talk about support in terms of hope, like instilling hope in you. And in this conference, we've been talking a lot about compassion as well. Can you think of a time when you felt real compassion from some of those folks? What did that look like?
So I guess the most obvious thing for me was when I did initially join the drug court. I was very quiet and reclusive, and I just didn't follow a lot of things I should have been doing. I was just a didn't care personality. And it was obvious at the time, I guess, looking back. And I did I went up before the judge when it was my turn. I wasn't really on the path yet, and I got caught in a lie. And that accountability, but yet there was still redemptive to it, because what I felt was being caught in a lie, in front of the court, and kind of the walk back of shame to my seat. But I did feel some compassion because I was able to move through that and get support. And that was kind of tough. That was one of the tipping points for me in changing my direction too, because I knew that feeling and I didn't want to feel like that again.
Mm-hmm. Yeah, so you might have felt like you were walking that walk of shame, as you were saying, but the court and the people there didn't necessarily make you feel that. You felt like if I'm hearing you right, you felt like they were still like giving you another chance to redeem yourself. Is that what I'm hearing? Okay. I don't want to put words in your mouth, but that's what I feel like I heard. But that's great. That's awesome. Welcome, Leanna. Glad you're able to join us. We just got started with introductions, and was just kind of the first question of what was sort of the important factor in changing or moving the recovery process along and getting reunified with your children. So I'm going to go to Kyle first with a question again, and then I'm going to go to you, Leanna, next, and ask for you to introduce yourself and then ask you the question as well. So Kyle, what do you think? What was sort of the most important, or one of the most important factors in your recovery process and reunification? Or actually, you haven't been reunified quite yet, but you do have your child back right now. Yes?
Yes.
Yeah.
Yeah, it was just before I entered into the recovery court, I was what do you call that when you I observed, and just seeing the compassion of the judge and how he sat down and, you know, and got to the level of the participants, and he remembered the children's names, and he was just so, you know, you could just see the compassion and the care in his, you know, and so that's what sold me right there, you know, just the whole team and the compassion and the care for, you know, the child and the parent. So that just won me right there. And so I was just like, yes, I want to do this. I came in willing to do whatever I had to do. You know, I wanted to learn a new way to live, a healthy way. And I needed the structure and the longevity of the program. So I was just so, you know, I was just ready. I had not done that with my previous case on the Northern Cheyenne Reservation, and haven't had my kids, and I just wanted to be a mom. I wanted to be a mom, and just seeing the support, and it's a massive support network. Just with every part of it, the judges, the attorneys, and they're just like, they have your back, and that feels really good. That's empowering, you know. Just doing the you know, the treatment. I started with Rimrock, and the counselors there were just great. And I just went in there with the attitude of, you know, I don't have to do these things, I get to do these things, you know. And so that's been my attitude, and then I'm just really empowered, and just really yeah, I just love the working relationships with everybody, and just how the team just works together for your best interest. And they call you on your things, you know, when you mess up, but they do it in a compassionate way, and that is really helpful. And they do it in a way that, you know, like Chase said, it's really, you don't want to do those things again once you feel that shame or the embarrassment of, you know, your actions, but the love and the compassion of the court having your back and helping you through that. It's just so amazing. It's very empowering. Those were, I think, just the compassion of the whole treatment court, and how they all work together, and, you know, and just, it's just the best interest of the child. And, you know, they make the parent feel so important too, and making decisions, and, you know, that's a big part with me too. And yeah, I think that was really the selling point for me.
Yeah, it sounds like kind of the combination between your attitude, your willingness to change, plus the relationships, the teamwork of the people that you that surrounded you are really helping you be successful right now. So that's
Yes.
wonderful. Yeah. Thank you, Kyle.
Mhm.
Miana, good morning.
Good morning.
So would you introduce yourself, just kind of who you are, your tribal affiliation, and then your experience with child welfare, and then kind of, you know, what you're up to now.
Okay.
Uh-oh. Oh no. Did she? Let's see. Oh no, I think we lost her. She's gonna have to, I don't see her in the participant list anymore. She might have accidentally left. So until she comes back, perhaps we'll go on to the next question. I'm sorry, she's having some technical difficulties this morning. Oh, nope, she's back. Kevin, could you re-highlight her again, please?
Sorry.
That's okay. You know what? I've done that before where I meant to hit unmute and then I hit leave. So
Yeah.
there you
That's
go.
exactly what happened. Okay. So I wrote it down because I knew, well, your advice. So I'm a Native American woman from the Crow tribe. I'm a mother of 5. 3 boys are adults and 2 girls are underage. I live in Billings, Montana. I'm a parenting support specialist, full-time at Bear Family Ties. After work, I'm always home cooking dinner and just spending time with my family.
Yeah, awesome. Can you say a little bit more about what a parent support specialist is? I just would love to hear more about that.
So I supervise visits with families involved with CPS. So yeah, like giving back basically.
Yeah, yeah. That's so awesome. That's so awesome
Mhm.
that based on, sort of your own experience, you wanted to then give back to other families going through similar
Well, to be
situations.
honest with you,
Uh-huh.
I didn't actively look for this job. It kind of found me.
Oh,
And
okay.
yeah,
Well, that works too,
yeah,
right? And
yeah.
sometimes that's better because you didn't know that that's what you wanted to do,
Mhm.
right? But then when they find you, then you kind of realize, hey, this is really meant for me. But whether you found it or they found you, we're glad you're in that position because I'm sure a lot of parents are really benefiting from your wisdom and your experience. So
Yeah.
thank you for joining us.
Mhm.
Could you also then talk a little bit about kind of what was one of your most important factors in the recovery process and reunification with your children?
Um, let's see, probably just them being taken away from me is what really helped because I don't know, my kids are my life. So, and I wasn't making good choices, obviously. I was leaving them with family, and my mom is was way older. She's since passed, but anyway, I left them with family, and then the family had to work, so they took them to my mom, and everyone got sick, and they got taken away. But I was on meth really bad. I lost my train of thought. I guess what helped me the most was just my own willingness. Like, I just wanted my kids back. So I was done. I was just done with myself pretty much. And I didn't think I was going to stay sober, to be honest. I just had to tell myself, just for right now, just for right now. And I don't know, one day I just started feeling better. And yeah, but I think what helped me the most, let's see, in the beginning was when my social worker, I just broke down to her and started crying, told her, what was really going on, that I was still using. And she helped me get into the second chance home. And I was reunited with my kids in like 2 months. So that's what helped me the most.
Yeah. So you sort of had a wake-up call when your children were removed. But at the same time, then you were able to also be vulnerable and open with your social worker. And that really helped you to find the resources that you needed to get your children back. Yeah.
Yeah.
Okay. Okay.
Yeah.
Thank you for sharing that. Thank you for sharing that. And Kyle, I mean, I think you mentioned too earlier about sort of all the different people that you developed relationships with, and we were talking about how you're sort of a super user of services, right? Like you're really connected to a lot of the community resources. Are there specific kind of community resources and relationships that you built through them that have been helpful, that have been encouraging for you?
Yes, Dress for Success has, before I even enrolled in the family recovery court, I signed up for a budgeting class there. And so it helped me, just the budgeting and breaking down your budget and your goals into smaller goals. I used that in my life and did that from the goals in my life, just the concept of a budget. So that really just changed my outlook on life and the way I viewed money. And then I got involved in I'm at the Hannah House. I was there for 10 months. And that was just a good community, a good place to build my foundation on, and the love and the support of God. Just building my foundation on that. It just opened up a lot of opportunities, like with Love Inc. And that's a church-based program that offers budgeting classes, affirming potential classes. I'm doing parenting. I got one more class with them. Boundaries classes. I've been with them for over 10 months now. And that's every Monday from 6 to 8. And that has been a really powerful impact in my life, and to be a good steward of not only my finances, but my whole life as a whole, you know, every aspect of it. And so that too just impact, that just greatly just increased what I learned at Just for Success. And, you know, just being the first one to complete the Just for Success, I got to be a spokesperson and speak at their annual fundraiser and tell my story. And then I also got interviewed on Color 8, and that was pretty cool. And I just love doing things like that. I love sharing my story and helping others. And two, I think that just the whole treatment court, just the support and the structure that they give you and the accountability, that is just, it gives me goosebumps, because our support system is so huge, you know, and we learn to, you know, tap into these resources. And I've even had like bankers that want to be a part of my, you know, my journey that I met at Just for Success, and just, you know, building my support circle like that. And I'm with Voc Rehab. I'm starting my own business, and it's a media consulting business. And I'm going to use that to promote companies and promote other, like, you know, programs with like the reservation and places that don't have that connection to those programs. I want to promote that in my business. That's going to be part of it. Yeah, I've been working with Voc Rehab since, let's see, and it's been about 6 months now. So I'm slowly working on my business plan with them. I utilize, like, I got my Section 8, and I have my own home now. I have my own apartment. And I utilize like any, like the Mira program for my rental assistance. I have tapped into those resources, HRDC, just every place that I can get assistance, you know, to promote, to keep this new lifestyle running. You know, I just love it, and I love the resources, and, you know, and I share them with my court, you know, the other court participants. You know, anything I find out, I share, and I, you know, I just want to, like, come on, do this, you know, this is working for me. So yeah, I just love new resources and stuff, and just meeting new people and building my support network. It's just really empowering, and it's just amazing, the people out there that care. And just my, like, the judge and the attorneys, and, you know, coming to court with us. When I first came in, I had like so many warrants, and I didn't even know I had a felony warrant. And, you know, just the fact that I had to go and face my problems. Every time they let me out of jail, I just ran, you know, I never went back. So, you know, just going in there and facing those, and having, you know, the attorneys and the judges having your back, the whole team just having your back, it just, gosh, that is it just warmed my heart. And, you know, I just loved it. And gosh, that was just so amazing.
Wow. Not only are you a super user of services, but you're super motivated and super inspirational. That's a lot that you are doing. You must have more than 24 hours in a day. But that's just yeah.
I learned time management with the time management tool that they had in court too. You know, the time budget. Yeah, that too.
Okay, where do I sign up for that? Budgeting, time management, boundaries. I need to sign up for those classes.
Love Inc.
Love Inc. There you go. There you go. Well, thank you so much for sharing all of that, Kyle. You are keeping very, very busy in a lot of good ways. So
yeah, I kind of have to fill my head with good things, since and it replaces all the bad stuff that I had in there. So I'm relearning things and just filling my head with lots of good stuff. So yeah.
Wow, what a great strategy to
Mhm.
replace the stuff that we don't want there anymore with good
Mhm.
stuff, right?
Yep.
Yeah, I love that. I love that. Chase, back to you too. Any particular sort of relationships along your journey that were supportive to you, that helped you along? I think you might have mentioned some before, but I just want to give you another opportunity to talk about that if you wanted to.
Yeah. So with my therapist, that was the strongest, most beneficial one. But it's hard to say even that, because when I got my sponsor, you know, they said always pick somebody who you want to be like, right? So that way you can listen to them, or someone that you respect or something. So, you know, I carefully picked the sponsor, and you know, joined the group and took on responsibility at the group. And it was even that was a growing experience for me, because, you know, I usually am quiet and I listen twice before I talk and stuff like that. I don't really, not too outgoing, but upon taking this position as an activities chair for a group, you know, I was able to grow and be more sociable and stuff like that.
Yeah. Thank you. Thanks, Chase. Wow. Well, we've heard a lot of great things that have encouraged you, and relationships that really supported you. But we all know also that the child welfare system that involves all of us on this Zoom meeting, we have some challenges too, right? And so I'm just wondering, like, you know, some of you mentioned some struggles initially, I think in our previous phone calls, you know, about trying to even reach people and not being able to reach them, or meetings getting canceled, or just a lot of things that, you know, that were a struggle in trying to get your children back and get treatment you need, services you need. And so I'm just sort of wondering, based on your experience, what could we do or say to positively impact the rapport with our parents, our working relationship with our parents? What are some things that, if you can recall, for those of you who are out of the system right now, in your experience, what are some of those things that you said even then, gosh, I wish they would have, or I wish I could have had, you know, something to that extent? And for those, or for Kyle, you have an open case right now, but is there something specifically that, in addition to all the things that you've accessed, is there something that's missing? Or is there something that we could do differently, just even in the way that we show up, right, with families? What are some things that we may be able to do better? Is there anyone specifically who would like to go first? Okay, Kyle.
Okay. Yeah, so when I had initially been in the hospital and had to meet with the social worker, my first CPS worker, it was just the fact that she was so compassionate and really took my opinion into consideration when asked about the placement, you know, and I wanted the placement to be with my mother, and just feeling that importance of being you know, included in the decision, really, that just gave me just, you know, made that relationship great, and made me want to work with them, you know. And yeah, just that compassion of the social worker and just being part of that decision.
Yeah, having the say so in the decision, right? Instead of
Yeah.
saying, and we cover this, Heather and Brooke cover this earlier today in the training too, where it said it's not about giving you a plan and saying, here's the plan, right? But it's that you get to say, this is what I want the plan to be,
Yeah.
right? Yeah, that's so good. Thank you for sharing that. Okay, how about anyone else?
I'll go. What
Okay.
was your question again?
So just about like, what could we do to improve the system? What could we do to improve your experience as a parent in the system? What could we do differently?
Well, I forgot to mention I joined the drug court, but when I moved into Second Chance, my older son was 13 and he wasn't able to move in with me. And that was really, really hard for all of us. I still remember the day I went to pick up all my things from the house, and yeah, it was just hard. He was crying, and yeah, that was rough.
Yeah. Being able to stay together in some way.
Mhm.
Yeah, absolutely.
But I mean, at the same point, the Hannah, or not the Hannah house, the Second Chance house used to, they would pay for cabs for him to come and visit like five times a week. He'd get a cab from Lockwood all the way to the West End and then back. I mean, that helped. Just so they, you know what I mean? Like we met halfway, but
yeah,
it would have been better if he was with us.
Yeah.
Mhm.
Thank you. Thanks for that, Leanna. Chase, do you want to add to this?
Yeah. Just because my journey, I believe, happened so perfectly, it's hard to say what could be improved, but I know I got to experience something, a change in the drug court when I was in the program. So when I first started, there was sanctions. You'd get community service hours. The judge sat up on his I don't know what to call it, altar. I don't think you'd call
His
it
bench.
his bench. Yeah.
We need a bench.
Yeah, and so I remember they went on a training, and when they came back, they put a bunch of changes in place, and one of them was more. There wasn't any sanctions, no more community service hours for like not getting your meetings to a weekend and stuff like that. They incentivized another way instead of giving out consequences. And another big change was he did sit at the same table or bench as the whole team and you. And that helped because it just brought it more to a conversation instead of feeling like an interrogation or like actual court, even though I guess it is actual court. Was just, it helped a connection.
Yeah. It feels a little less intimidating, right? When they're with you at the table. And you can see sort of eye to eye at that level. Instead of, as you said, to the altar. I like that, the altar. Yeah, so there is a difference there, even just seeing somebody eye to eye. Thank you for that. It seems like we're already moving towards, what are some specific things that really worked well? I mean, there's not a whole lot of doing better, but even, as we think about what really went well for you, I think those could also be hints for us in really improving, some of our practices. And I know, Kyle, you talked about in our prep calls, just even the birthday party with the cousins, right? Could you say a little bit more about that?
Yes, I have two cousins that are in the system, and they've been in the system for a while. And I and my older daughter since their mother was not, you know, trying to be involved in their life, we reached out to the social worker to see if we can get visits or at least call them. And so they met, and it was approved that we could video chat them. And from there we built a relationship with the foster parent, and you know, and the visiting services that they went through. And they were able to attend, you know, because we have a lot of parties, a lot of birthday parties for everybody's birthday in our family, our extended family. And, you know, and so it was great that they got to come out, the visiting service brought them out to the birthday, and, you know, and they got to be a part of the birthday. And we've done that, and we've got to go to their birthday party and just be a part of theirs as well. And I think that is just an amazing thing that we're able to do. And it, you know, just that extended family, and, you know, as long as they're healthy, you know, I think that just being a part of that, you know, and getting to know the family and knowing the ones that are, you know, stable and able to, and that want to be a part of their life when their parents aren't there, you know, we didn't want to lose that with them since they've been in the system for so long. And so that's just an amazing part that it just warmed my heart that we were able to have those, you know, have the capabilities to do that, you know, the technology and stuff, and just a good working relationship with their foster parent. And, you know, getting that back into the lives of my, you know, my cousins, and, you know, keeping our family together, because it's been hard after COVID. And, you know, so yeah, just that part was very amazing.
And I think that really goes to, you know, our continued conversation around the importance of family, importance of extended family connections, as well as then continuing those family traditions, right? Like birthday parties, like big family gatherings, right? And so, you know, to that end, so our last question really is about culture and culturally based services. So over the course of your cases or your current case, have you had the opportunity to incorporate any culturally based services into your plan? If so, could you share about that? And, you know, as it was in conjunction with sort of the traditional services that we offer, and like what about that is important to you, or if you haven't had a chance to do that, what would have been helpful? What would have been honoring of those family traditions, of those cultural traditions that you would have wanted your children specifically to be able to continue to experience even while in care, right? So, you know, did anybody experience any of those culturally based services? Or if not, what would have been helpful?
Yeah, Billings Urban Indian. I did with Billings Urban Indian Health and Wellness Center. I had got to transition from Rimrock from the day treatment. I did part of IOP at Rimrock, but I went to Billings Urban Indian because of the culture. I needed that cultural connection. That's what I was missing in, you know, in my recovery. So having to be able to smudge in the morning before our classes, and just doing the Wellbriety, that was the native 12 steps, and being a part of the talking circles, that just really connected and really lit my fire for my recovery again. So just being a part of that, and doing the things, and like with Native American Development Council, and they have just all kinds of activities, family nights. Those are just great things that I got to be a part of, that just really, really empowered me in my recovery.
That's so good. And Kyle, for people like me who don't really understand what some of those cultural practices are, like smudging or talking circles, can you describe just a little bit about what that is, the significance of that?
Yeah, smudging is like just covering yourself with the smoke and a protection, and just warding off like the, you know, the negative energies out there.
Mm,
Yeah.
okay. And what about talking circles? What is that about?
It's just like the AA and NA meetings, but we do it with smudging and praying. Praying and smudging are a great part of my heritage, and just praying over the day and the people and everything and your walk, and just keeping that connection with the with God creator.
Yeah, awesome.
Yeah.
Thank you for that.
Mhm.
Okay, Leanna, how about you?
Well, I experienced the same doing well-variety through Angela's Piazza, and it was just women. Because I experienced a lot of trauma growing up on the reservation, and like we had talked, I struggle with finding positive things about my culture, just because of all the trauma I've been through. But yeah, Angela's Piazza, I mean, I still go there, still involved. And Sister Mary, who retired, she's one of my best friends. But yeah, I still we do the smudging, and then we share, and I'm actually more involved now with the Daughters of Tradition. My 10-year-old goes. My older daughter used to go, but she's too old now. So me and my 10-year-old go, and I really enjoy it. Like just getting to know all these little girls and helping them feel safe and listening to them. And yeah, it's good stuff.
Awesome. Awesome. Thanks, Leanna. Chase, do you want to add to this conversation?
Yeah. If I can, I would like to, I just remembered something from the previous question of,
Sure.
Is there anything to improve upon?
Mm-hmm.
And so just from my case to where there was a parenting plan and things like that that needed to be, I guess, in place when I transitioned, a lot of this stuff was or graduated. A lot of the legal stuff for the kids was kind of like I still needed a lot of help in that area, because it was I guess, the kids were in my custody, but then when I transitioned out, there's still the whole other legal side and the other parent and things like that. So, and it seemed to me that it's not too much like an area of attention. And maybe if I did have some help or support in that area, that kind of would have made me feel better about it, because there was, it's kind of scary, especially after, going through a program. But I guess it is manageable because I am working through it. But that's just kind of something I noticed too, is that after you transition, there's still the legal parenting plan or whatever that kind of is up in the air.
Yeah.
That's kind of overhanging everything.
Right. Yeah, sometimes we call that post reunification services, aftercare, a lot of different things. But you're right. Like when you've had all these supports, and then all of a sudden you feel more alone, and you still have things that you need to do, and so it would be helpful, right, to have more supports after the children are returned. Yeah. Yeah. Did you have anything else to add about cultural connections or services that are more culturally inclined?
So I also did the talking circles and the world variety and stuff like that, but that was something I pursued, you know, just because I believe that the more perspectives I had, the better off I would be. Kind of a holistic approach. So I did, you know, do all of that, and I participated in a peer mentorship, and you know, that was another really critical relationship too that I forgot to mention earlier. So I had a peer mentor, but that was also culturally centered because he was also Native American, and
Yeah.
they're all natives, you know, in the family drug court, and they did justice projects that were culturally based. Like one of them did a sweat, and the other one did kind of an information. So yeah, I like that. That was cool.
Yeah.
Just
Yeah. And that,
having the kids with, I guess, the grandparents on the family side, you know, who are also natives, that I think helped them too in a way, just be more comfortable.
yeah. And you talking about the peer mentor who was Native American, that actually reminded me that you also spoke before about the social worker who was a person of color, who was Hispanic, right? And
Yeah.
you felt like, can you say a little bit about that? I don't want to speak for you, so.
Okay, yeah. So that did help me, I guess, low key just feel a little better about my social worker, because it felt like, you know, something that just made me feel a little better. It's hard to explain about getting
Yeah, maybe, yeah. I know as a person of color myself, sometimes I feel like, you know, if that other person that I'm working with is a person of color too, there's a certain understanding, right? There's a certain I get you kind of thing, right?
yeah,
I don't know if that's what you mean, but I know that's how I feel sometimes too. Okay, there is a
pretty
question
much.
in the, yeah, there's a question in the chat asking how long it took for the reunifications to happen. So for Chase and Leanna, how long did the reunifications take with your children?
Until they were back in, like, can you
Until,
specify?
yeah, so I'll just say reunification as in case closed. So from the time they were removed to the time that the case was closed and the children are back in your care, and how long did that take? How many months or years? You know, you guys have to kind of think back a little bit, don't you? It's been a while.
I think it took me, it was like 2 years and 2 days.
Okay. Okay.
Yeah.
Chase,
In the drug court program. Yeah.
For me, it was the same, about 2 years. I was in the family drug court for about 2 years.
Yeah.
A little
And I think that's a little bit of the uniqueness of the family drug court, right? Is that the program itself runs at least a year, I believe. And so that could sort of lengthen that process, that reunification process, just by the nature of its program, right? But for good reasons, as you said, you guys are all trying to, yeah, we're back in there much more quickly than the 2 years, yes. Yes, the children were returned to them. They were living together, correct, right? Earlier than 2 years. So, and I know there was a second part of that question about whether that was a stressor that affected their success, but I'm not quite sure what that part of the question is asking. And so, Sherry, would you like to just kind of ask that question? Get off of mute and ask it? Or
Yes,
if not-
I could do that. I
Okay.
was just wondering if the long time that it took for your children to be reunified, did that bring a lot of stress to you, or did that allow you to be more successful? Because sometimes reunification can take some time. And I was just wondering more on the line of was that a big stressor for you that you didn't have your children, or did it allow you to become more successful?
Leanna, do you want to answer that question? And just to clarify, so your children will return to you 2 months,
Yeah.
right? After 2 months, but it took you a longer time to graduate from the program, right?
Yes.
Yeah. Okay.
Yeah.
So could you then?
I'd have to say having them with me helped more because I knew they needed me, they wanted me, I needed them, I wanted them with me. Because you only know your kids are safe when they're with you. And so that helped a lot for me. Yeah.
I appreciate that, because you kind of forget that you need to know that they're safe also, even though they're placed someplace else. So that opens my eyes a lot.
Yeah. Thank you for that question. Okay, well, we are just out of time, but I did want to just provide one last opportunity. If anybody wanted to say something that you didn't get a chance to say, that you're like, oh, I wish I would have said this. Is there anything else that you'd like to tell the group before we wrap up?
I just wanted to answer the question real quick.
Sure, yeah.
Okay, so for me, it didn't really, no, it wasn't a stressor. There was a lot of stuff going on in my life, and I knew that I'd get the kids back. So I just kind of said, okay, this is my time to work on myself, find out who I am without being, a parent, a father, or any relationship, kind of have all those identities taken away. So for me, it kind of helped me build who I actually was. And then, I knew I was going to resume the role of a parent soon. So I just used that time to work on myself a lot.
Thank you, Chase.
Thank you.
Okay, final last words from anyone.
Thanks for listening.
Thank you for being here. Such inspirational stories, such stick-to-itiveness. You guys persevered through a lot. And we're just so fortunate to have you share with us today and take time off, taking the time off of work and school. We're just so thankful for what you are teaching us today and what you're sharing with us today. I think we're going to be hearing from you more. This is just a guess, but we're going to be hearing from you all a lot more in the future. So thank you again for being with us. And back to Judge Gustafson, I think.
Well,
Thank you.
we're going to, we've been going quite a while now. I think we do need a break. We're a little over our time, but maybe we take a break now. And when we come back, we are going to dive into our affinity groups. And I know we have some questions for the affinity groups. Are we going to put those in the chat of the group, or are we going to list them now? Maybe Kelly, you know the answer to that question.
I think I'm going to put it in the chat, the questions in the chat when we come back.
Okay, so we'll take a 5-minute break. I realize that's a really quick break. And so we'll come back here at I got 11:25, and then we'll break into affinity groups so that we can have some further discussion. So thank you again all for your willingness to come and share your information with us. It's always nice to hear from folks that have actually lived through and in the system that we work in. So thank you again. And we'll be on break.
Judge, should we just, even though some people still aren't back on yet, should we introduce the break or the affinity group breakout?
Yeah, I was just looking to see how many people we had back. We have quite a few, so.
Great.
Well, we're going to
Um,
break out into affinity groups, and so I know that Kelly was going to put in the chat the questions for each of the groups, and then I think Kevin is going to send us to the affinity group, if I'm correct.
Yeah, and Kelly did put those questions up.
Okay.
Brooke is just gonna read them really quick.
So from that article, we know that empathy requires recognizing the emotions of another, and being compassionate means feeling motivated to act to alleviate suffering. So what we would like you to discuss in your affinity breakouts is, number one, how you can implement compassion in your individual role, both inside and outside the courtroom. Number two, share an example of a situation where you demonstrated compassion in your individual role that was successful or impactful for the parents or families or caregivers. And then third, share an example of a situation that in hindsight you wish you would have demonstrated more compassion.
So we have about 20 minutes on that breakout. And then we're gonna go right into our teams from there. And we'll put the team chat up in the chat box when we get there, I think is how we're doing it. So.
Okay, do you want me to send people to their rooms now? Or?
Yes,
Yes.
please. Thanks, Kevin.
Yeah.
Hi, this is Melinda. I came in just a touch late. Am I in the right room?
No, I don't have you in one. Who should you go with? I can assign you to one. What's your profession?
Executive Director of CASA.
Okay, so I'll throw you in with the CASA group. Okay, sounds good. See ya.
Thank you.
Yeah. And how about you, Senator or Taylor? Do you know where you guys belong? I can send you there.
Yeah, I'll be with CPS.
So, and that was Taylor to CPS?
Yep.
Okay.
Kevin, what are the options?
There's CPS, CASA-GEL, OPD, tribal, county attorneys, or judicial.
Okay, I think maybe put me in OPD.
Okay. See you later. All right. So I think that's okay. So what I'm going to hope to do here, Kelly, is when we all come back, I'm going to go in and remove the infinity rooms. So when we break it, when we open back up, all they should see is their team rooms. They'll have to go join them themselves. I can't, but
yeah.
So they were great speakers.
Yeah, I thought so too. They were wonderful.
I do a lot of stuff for treatment courts also. And we get the speakers there, just they've always been great. And these guys would fit right. Well, they were in treatment court themselves. So
right. Yeah.
It's amazing what that program's done for people.
Yes. Yeah, totally. They're wonderful. Okay, I'm going to take a little break myself and I'll be back in 20 minutes.
Yeah.
Yeah, so I think it'd be good to give them like a 5-minute heads up. So I think we should be back at 10:50 or 11:50, I should say.
11:50, is it over, or 11:50 is, so I give them a 5-minute at 11:45 or what?
Yeah, 5-minute at 11:45, and then we come back at 11:50. Then we go into our team breakout.
And you know what? I'm not going to open up that room until we explain to them what they need to do.
Yep.
Okay.
Sounds good. Thank you.
Okay. Bye. Looks like we still have a couple minutes for the other rooms to come back in, so.
Recorded.
So we're all back from our affinity groups, and we are actually now going to break into our team breakout groups. And I guess I'm going to ask Kelly again, do we have different questions or things we want our teams to talk about?
Yep, just put it in the chat.
As a team, discuss one thing each of you can do in the courtroom. Let's see, each of you in your individual role can do in the courtroom to demonstrate compassion in these cases. Court. And so we have a few examples here. It looks like thanking the parents, using a sandwich. I guess everyone can read those. And can you commit to doing that in every hearing? So Kevin, it's my understanding for this one, we actually go down to the little bit more, where it says at the bottom more on our screens. Go to breakout room.
You might not need to here. I'm going to open them, but what you want to do is go to your team room. Okay.
So you're right. So we go to the breakout room, and the team will be like what judicial group you're.
Yeah, exactly. So if you're with Judge Davies or Judge Whalen or whatever. Yeah. So I'm going to open now. Let's see how it works.
Pick your judge.
Okay, you guys can go pick yourselves.
All right.
like it's working easier.
Yay.
Might be easier this time. Hey, I emailed you the argument too.
Yeah, got it.
Okay.
Got it.
It's
Thank
just
you.
the audio. Is that okay?
Yeah. Yeah.
Okay. Yeah, I think it's working okay. And who's ever left, I will move you if you need help. If anybody needs help moving, let me know.
So I don't see Judge Berger on
Oh,
there.
Judge Berger's going to Judge Harada. Sorry, we should have probably mentioned that. So go to
Okay.
Harada's team. And then Judge Wilson is going to Judge Eddie's room. Sorry, should have mentioned that. Okay, how about you, Amanda or April, Crystal? Daria, do you guys need help moving? Do you need me to move you to a room or? You're muted. You're muted right now.
Sorry. If you could move me, that'd be great because I don't see that icon that I had last.
Okay, who are you going to? What team are you on?
Judge Best.
Okay, gotcha. All right, and then I think, okay, you should go. Yep, I think we're good. How about Amanda or April? What room do you guys need to go to? Okay, I think we're good. April, are you there? Kelly, I think this worked pretty good.
Yeah, I think so too. Nice job.
Much better than yesterday.
Yes, for sure.
Kelly, are we doing the fishbowl or what's going on now? So are we going right to 12:25?
No, so I think what we want to do is end our team breakouts at 12:15. So maybe
okay, so 12:10, I'll do a 5-minute.
Yep, exactly. And then we'll come back at 12:15. And then I believe we still want to do a fishbowl, but not necessarily maybe spotlight every single person because I think we only have time for a couple of people to speak. So I think Heather will just ask, does anybody have a burning issue they want to bring up?
All right.
Yeah, and then we'll just next steps and adjourn. Okay, thanks, Kevin.
Oh, yeah. Kelly, do you need to go to a certain room?
I was in there, but Judge Halligan's not in there
Judge
and
Halligan's in Judge Best's room. Don't ask me why.
yeah, so the Missoula people didn't know we
You want me to
just
go?
sat
You want me
there.
to join? I can join Best and ask if Judge Halligan's going to move. Do you want me to
Okay,
do that?
yeah, I thought this ended at noon and I actually scheduled a meeting for people.
Oh, no worries.
The Zoom, so I didn't know this went till 12:30 or I wouldn't
Yeah.
have scheduled
Okay,
this
well,
meeting.
I'll look.
I have to go.
I'll look. Yeah, I noticed that Judge Halligan was in Judge Best's courtroom, so.
Yeah, I just thought I'd let you know, there's only like 4 people in the Missoula
Yeah.
one and Judge Halligan's not there.
Yeah, I'll join Judge Best's and see.
Okay. All right, bye. Thank you.
Okay, yeah, you bet. Bye.
Is there a distinction there? I mean, there's an acknowledgement as opposed to a waiver. Just an acknowledgement seems to be just that. ANS is acknowledging it doesn't have sovereign immunity. With respect to the fourth,
I never can seem to get in the right room. So I don't know if they're almost, can you move me to the right place?
Yeah, give me just a second here.
Sure, thanks.
You bet.
So it is. Morning. Number. Notice that we is participating. Looking at the argument. Yeah, I'm Bill Sparks, attorney with Firm Baden Wozniak. With me, I have Andy Patton of Wings. I also have John Stafford with me, who is here on behalf of Lustre World Company, Montana LLC, and Erewhon Orthopedics. As we discussed, hopefully going to reserve about 10 minutes for rebuttal. And what started off as a pretty simple quiet title turned into a relatively more complex case of sorrow.
Kevin, are you able to get Judge Halligan into her room?
I put her in her room, but I don't know what she's in there, but it says not joined. So I don't know if. Let me see here.
Oh, it looks like folks are coming back already.
I believe our schedule said we were doing fishbowl from 12:10 to
Looks like people are coming
12:25.
back anyways.
Yeah, but we were gonna extend the team time a little bit more because we were behind schedule a little bit, but that's fine. This is fine.
White versus University of California. He maintained that the district court improperly applied second, third,
So for those of you who are back with us in the main room, did you actually choose to leave the room or did you get kicked off?
We chose to leave on the bottom.
Okay.
We thought it was time to go.
Yeah. Yeah. We were gonna give folks 5 extra minutes because we started late. So we might just hang out for a little bit until the rest of the gang joins us.
All right, I just sent a 2-minute reminder. Okay, closing all the rooms.
Is being recorded.
All right, we're all back from our team breakouts. And before we maybe have a few report outs, I did hear from one of our legislators this morning who is in our training today. And Ellie Boldman would like to just share a little bit about upcoming proposed legislation that with regard to child welfare cases, and kind of give us an update of where we can go to follow legislative bills and things like that. So Ellie, if you're there, maybe you could take a few minutes and share that with us before we get on towards wrapping up the day.
Well, thank you so much, Justice Gustafson. I hope everyone can hear me all right. For those of you that don't know me, I'm Senator Ellie Boldman from Missoula. I've been in the legislature since 2011. So that's 3 governors now I've had the opportunity to work with. And I just wanted to use this just brief moment where I have all these amazing stakeholders in a room to share. One, I'm a legislator, but I also am an attorney in practice that has experience with DN. I work as a contractor for OPD, but also represent interveners and foster parents in a private practitioner scope as well. So I love the work, and I just can't thank the folks that put this training together enough. It is so needed, and it was so valuable, and I will love to continue to be a part of it. There were 2 things I just wanted to share. One is that in the years that I've been in the legislature, there's not often opportunities to see a lot of interest and bipartisan support for types of legislation. And over the last a couple sessions anyway, the interest in moving the dial when it comes to youth in need of care in the state of Montana is truly statewide, urban, rural, tribal, Republican, Democrat. And I share that because last session we did introduce an interim study, a legislative study. The scope of it was to really more look at kids in foster care through regions of DPHHS. That study is out. I would really invite folks to take a look at it. But I can tell you that the legislative interest is not done. What we learned, I think, from the data that came through that was that there are regional differences and we have opportunities. But that I think the legislative takeaway was that, you know, our zip codes should not define our destiny when it comes to the justice system. I will say that the scope will continue into next session to not only look at now regions of DPHS, but the district courts themselves and what some of the differences are in how district courts perhaps are perceived as not always having consistent ways that the cases are handled. So including all kinds of things. And I invite you all to reach out to if you have an interest. I know there's a lot of interest in how district courts, whether they appoint attorneys for children and how that's very different from district and what's sort of the best practices there on what's working. The second thing I wanted to share is that I'm sure many of you are aware that there is a number of proposed legislative changes to the statutes in DA cases. They are significant proposals. There is a lot of bipartisan support for some of them. And then I anticipate some of them will be very contested. There's also a pilot project being looked at to maybe look at creating some DN courts. And then, of course, there'll be a further expansion of the legislative study looking at the work we do. I want to encourage you deeply with my whole heart to please follow and track these legislations. We are holdover Senate. I'm a holdover senator, which means that I am here for 4 years, so I'm not up for re-election, which means I can put in bills right now, and so can a number of other legislators. Those are already up. They are called, what do we call them? LCs. They're an LC until they become a House bill or a Senate bill. These unintroduced bills, they're up right now. You can see what some of the proposals are. And through that legislative website, and I'll give you my cell phone number, but I'm happy to help you stay engaged, be a part of the drafting of the legislation, and certainly please be a part of the testimony, either support or in opposition of bills. We are a citizen legislature, which means we just are normal people with day jobs, and very few of us are attorneys. And so you're really relying on folks that are ranchers and teachers to make massive decisions about our laws. And so we really need the experts, like the people in this conference. We need you to weigh in, and it's so critical. And there are tons of ways and places to track the bills as they go and to participate in the process. So anyway, thank you.
So Ellie, you say that a number of these bills are already up. Are there any that you're thinking are quite significant, or how many of them are there, or ones that you think in particular that you know would interest this group of folks? I'm just curious. I haven't looked at all of them yet. You know.
Well, so yes, I mean, if you followed some of the interim committee on health and human services, they had a bill come out that's fairly massive. So that will be everything from warrants being required for removals, appointment of children in cases. A number of legislative changes are being proposed. I think quite a few of them will become law. And so the way I know the county attorney's office, the Department of Justice, the different agency, or what we call lobbyists, but the different stakeholder groups that come will certainly have opinions on all of these things. And so where we all fit into that is what we call how we make the sausage over there. So you can look right now and see the introduced bills will just be what's called a bill title. So it may say something as simple as generally revised DN laws. Some of them are more specific. I think Representative Dennis Lenz, who will be moving over to the Senate, he has a number of proposals that show some more specific language in the introduced bill section. However, it's if you ask the legislative services, it's public that they can release the correspondence between the legislator, and you can find out more information there. And certainly lobbying groups are already doing that. I'd be happy to provide my cell, and you can email me and I can get you a lot more information.
All right, so maybe you could provide that to Julie and she can get it out to at least the folks that are on the training today.
Yeah, and Julie certainly is an expert because she used to do that.
Yeah. So I think Heather, you wanted to talk about a few.
We realize yes, so we are at the end of time, or close, but we really did want to hear from one affinity group. So Brooke, thoughts?
Is Judge Whalen on?
Yes.
Judge Whalen, would you mind sharing some of your thoughts from the affinity group and then also just from your team?
I don't understand how I get picked with a W as my last name. You know, I grew up in life always being the last one in the line, and for some reason, I always get picked for these things. No, our group, we had a good discussion about, it was primarily about how we're looking at some changes within the court, in our courtroom and in the way we handle our procedure. You know, we talked about more collaborative approach to doing things. And, you know, one of the big, one of the concerns that was brought up was with regards to ICWA, with regards to active efforts. And unfortunately, our group was cut short quite a bit because we did talk about some other areas where we thought some improvements could occur. And I informed our group that, you know, we were going to be having another meeting here in my courtroom with the parties involved to discuss active efforts and what those should look like, you know, some ideas of what the department needs to do to further implement active efforts in those cases so that we can make sure that we're breaking down as many barriers as possible to move our cases forward in the best interest of all those involved.
Nice. Thank you, Judge. Should we wrap up? Okay. Yeah, Judge Gustafson, do you want to?
Sure. Well, we're going to wrap up here. We're here at 12:25, and it's sort of the next steps. We've already heard some next steps from Judge Whalen's group, and of course, would encourage, you know, all of our judicially led teams to have a follow-up meeting in their jurisdiction and maybe talk about some of the things that you know, they could do more productively to get better outcomes in not only ICWA cases, but continue the discussion with regard to other cases as well. We do hope that this training has been beneficial and provided you with some practice ideas and most importantly, some collaborative contacts with various tribal members to improve our work with the Native American families that we are serving. And as our court improvement program goes forward and makes plans for what our next steps are, we also want to seek some feedback from you as to any child welfare issues that are present in your work or other areas that you'd like to have discussions or trainings on or look further into. So if you have those ideas, I would encourage you to provide them to Julie Burke or to myself or even Heather and Brooke, and so that we can start planning for our next steps as we move forward as well. So I do appreciate that everyone gave time for the last 2 mornings, and we hope it's been beneficial for you. We want to wish you a great rest of your day and rest of your week. And Julie, do we have anything else we need folks to do before we say goodbye?
Thank you, Justice Gustafson. For those of you who are attorneys, there will be CLE credit. So if you email me your state bar numbers along with the number of the time frame that you attended, then I will submit it to the CLE Commission once they haven't approved it yet because I just submitted the application last week. But if you give me your state bar numbers and the number of hours that you were at this training, then I will forward it to them. So thank you.
Thank you,
Oh,
everyone.
and one last thing, I put this in the chat, but Brooke and Heather's training materials, they have an ICWA bench card, their PowerPoint. Is there anything else? They will be posted. Kevin Cook, our IT person who did all the logistics for this, I really want to thank him. It was complicated. He will post all of their materials onto CIP's website probably next week and at cip.mt.gov. And right on our homepage, there's a moving the dial icon and you just click on that and it should be self-explanatory because we have all of our moving the dial trainings in chronological order. So this recent one will be up on top. Brooke, did you have other besides the ICWA bench card in your PowerPoint? Was there anything else?
We'll post that compassion article.
Oh, okay.
All right.
You want to send that to me?
All right, well, we'll say goodbye and maybe the folks that were involved with planning this can hang on for just a few minutes.